Good morning, everybody. Happy Monday. Welcome to TCF Live. My name is Dan Soul. I will be your guide on this 3-hour journey through Courtlandia. We start in Michigan. This is Magistrate Chisholm.
This is citation 26RO03126. Ms. Douzber, you were cited back on the 10th of May of 7:30 in the evening for driving a vehicle on Woodward near 12 Mile and Royal Oak with expired plates, and you had no proof of insurance. Was the vehicle insured on the 10th day of May?
Yes, I have insurance here, and actually, I wasn't the driver of the car. My fiance was the driver of the car. I'm just on the registration and everything. When the ticket was given, I assumed that it would be given in his name, but when we received the ticket was in my name. But I have proof of insurance and everything here.
Can you put the certificate of no fault insurance in front of the camera? And then if you speak, that'll focus the camera on the document. We can read it. You need to speak, please.
Oh, yes. I'm sorry. What did you need me to say? I'm so sorry, sir. I could not hear you.
I asked you to put the document in front of the camera and then speak, because the sound of your voice will make the camera focus on you and we can read it.
Yes, sir. Here you are. Here's the document. Here's everything that I have here.
That's a registration, ma'am. I asked you for a certificate of no fault insurance.
For the insurance, let me see. Here it is. I'm sorry, sir. I thought that was what I had. Everything is right here.
What is the effective date on that policy?
Oh, 5/11/2026.
You got the ticket on the 10th day of May.
Sir, as I said, I wasn't the driver, so as I said, I'm just presenting to you what I have.
I asked you if the vehicle was insured on the 10th day of May, and you said
At the
yes.
time,
I'd like to see a certificate of insurance that's effective on the 10th day of May, please.
I don't have one, sir. At the time, I was under the impression that it was. As I said, I am not the typical driver of the car. I'm a stay-at-home mom, so I'm usually never in the car, sir. As I said, I wasn't the driver, so I can't.
Was the vehicle insured on the 10th of May or not?
I guess not, sir. If it says that the effective date was on 5/11, I guess not, sir. I was under the impression
Do
that
you
it
have
was.
another certificate that would be effective?
No, sir, I don't. No, sir, I don't.
Officer, Ms. Douzber has indicated she wasn't the driver.
Yes, sir. If I'm remembering this correctly, she was the passenger in the vehicle. I didn't find it to be fair for the driver to be issued a citation for something that he wasn't aware of when the actual owner was in the vehicle that would be responsible for having insurance.
Sir, I'm not the owner of the car. That's what I'm trying to explain.
Ma'am, if you'd let me respond.
Okay.
The violation is not owning a car that's not insured. And the violation is not owning a car that isn't licensed. The violation is operating that vehicle that isn't insured and or licensed on the streets. So both of these tickets will be dismissed.
Thank you, sir.
You're all set. Thank you.
Thank you.
All right, Magistrate, I have Officer Craig here.
Okay, thank you.
Yes, sir. Thank you.
That.
There we go.
Yeah.
Sorry about that.
Not a problem. This is 26RO04006. Citation was issued on the 8th of June, 4:28 in the morning, near 12 Mile and Alexander Streets in Royal Oak. You were cited for driving on expired plates. When did you replace the plates or tabs?
I purchased them online that day.
Did you have the new registration with you?
I do.
Your finger is on the date that I need to read. If you would read the bottom number on the left-hand corner, the first 8 digits.
0608.
Gotcha. So Craig, is there anything you want to add to this matter?
Yes, I would like to make a motion to dismiss the citation, Your Honor.
Thank you. Mr. Attorney, thanks to the officer's motion, the ticket is dismissed.
Appreciate your time.
Thank you. Have a good day, sir.
You too. Thank you.
Raven Wilson
Yeah, that's correct.
is here. Your ticket is 26RO03685. You were ticketed back on the 28th of May for driving on expired plates. When did you get the new plates or tabs?
Pretty sure I went home that night and got them, or the next morning.
Do you have the new registration with you, please?
Yeah, it's right here. This is backwards.
No, it's on 6/29 is the date that I read. Yeah. Counselor Craig, is there anything you want to add?
Motion to dismiss the citation, Your Honor.
Mr. Wilson, you are good to go. The ticket is dismissed thanks to the officer's motion.
Thank you.
You have a good day.
You too.
Tom, if you would unmute yourself, turn on your camera, please. Ms. Hall, please unmute yourself and turn on your camera, please.
Unmute. Okay, I unmuted. Now, you said turn on my camera. Okay, let me go. This is all. Okay. Oh, no, that's not right. Okay. Can you? I'm sorry. I went to camera and the only thing showed up was my background. Can you hear me?
We can hear you, but your camera is not turned on.
Okay, so in order to go to the camera, I have to go to my camera, right? And then what will be on the camera is my background, right?
I don't know, ma'am.
Oh,
You see a line across the bottom of your screen that shows a camera with a red line through it?
no, all I see is this meeting is being live streamed, and I guess I hit okay. Okay, I hit okay.
There you go.
Okay.
Okay, this is ticket 26RO03693. Ticket was issued back on the 28th of May at 10 o'clock at night in the area of Royal Oak near Woodward Avenue and Lincoln Streets. And you were cited for making a prohibited turn. You can admit or deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed?
Responsibility.
Did you set up a hearing to make an explanation, ma'am?
Did I set up a hearing to make an explanation?
Yeah,
No.
you want to explain this?
Yes, I do.
Please do.
Okay, I was on my way to pick up my son from work. It was dark and I think it was kind of dreary. I didn't see the sign to the corner of my eye. And I proceeded down the street looking for where I was going. And then I saw the lights flashing as I got halfway down the street. I was kind of turned around, but I wasn't looking at the sign in the corner because I didn't see it. And that's how I made that illegal turn. And I'm asking the court to allow me to keep having a clean driving record because auto insurance is so high.
Is there anything you want to add to this, Officer Craig?
I
Yes,
can't
Your
hear. Oh, sorry.
Your Honor, I'd like to make a motion to amend to impeding traffic.
Ms. Hall, the officer's motion to amend to impeding changes this from a moving violation that carries points to a non-moving violation that does not carry points. Do you have any objection to his motion?
No, I don't.
I didn't think you did, but I do have to ask, so. So impeding carries a fine of $175 that can be paid online or by mail. Or if you prefer, you could pay it at the courthouse counter if that works out better for you.
I'll have to pay it at the courthouse. Do they have payment plans or it has to be all cash?
Well, they can take a credit card. You can do that on the phone, I think.
I have money in my credit.
Okay,
I have about $50 in my account.
would it help if I extended the time to pay by 30 days?
Okay, I can pay it by 30 days. Okay, I'll do that because I get a 1-month check. Okay, I'll do that.
Okay. Have a good day, ma'am. Thank you.
Thank you. Okay, hang up.
These matters were sent at 8:31. It is now 8:46. We're going to call the matter of Adam Lewis. Defendant has failed to appear. The fault will enter at 8:46. Waited 15 minutes. We'll call 26-0-3638 D'Angelo Thomas. Matter set for 8:31. It is now 8:46. Defendant's default will enter.
Good morning once again, everybody. TCF Live on a Monday. Nice to have you all here with me this morning. If you haven't yet, do say good morning to us in the chat. We love to hear from everybody. Relatively slow start out in Courtlandia. Going to ride with the magistrate here for a little bit longer.
I think that completes your docket, officer.
Thank you so much, Your Honor. I do have Officer Cole here as well.
Okay, we don't have anybody else. We don't have another driver in the queue yet. So
Okay,
Officer Cole's a little bit early, which is always good. If his ticket would show up early, we could certainly start his hearings earlier. But we can't start early without both sides here. So.
Unfortunately. Well, thank you, Your Honor.
Yeah, it'd go pretty quick if we could, right? Okay, we'll see why this other lady came back.
Yes, sir. I'm so sorry. I have a new baby. I was trying to mute the microphone and it accidentally disconnected the meeting. I didn't want you to hear the baby crying in the background. I'm
That's
so
not a
sorry, sir.
Well, the hearing was actually over, man, because I dismissed both tickets.
Okay, I didn't mean to. I didn't know if I
No,
wasn't sure what else to do.
yeah, I don't think there was no problem.
Okay, thank you,
Okay.
sir.
Thank you. Have a good one.
Mhm. You as well. Shh, shh.
Alrighty, friends. Once again, good morning. TCF Live on this fine Monday morning. As I indicated, relatively slow start out in Courtlandia, but looks like
Mr. Cole, can you hear me?
Whoop.
Morning, Your Honor.
Good morning.
Looks like Judge Flores has a contestant. Let's go say good morning to him.
Keon.
Yes, Mr. Keon Cowart.
All right, so we're on the record in docket 2601313. That is People of the State of Michigan versus Keon Cowart. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court. Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people of the state of Michigan.
And Mr. Harris.
Yes, Your Honor. Assistant Public Defender James Harris here on behalf of Mr. Cowart, who is standing to my right. Mr. Cowart, if you could please state your first and last name for the record.
All right, this is the time set for a jury trial in the matter. Mr. Smith, how are we proceeding? Would you like to defer to Mr. Harris?
At this time, Your Honor, the people are understanding that the defendant is going to enter a guilty plea as charged under 769.4A, and this matter is going to be set for pre-sentence investigation.
That is my understanding as well, Your Honor. The prosecution has extended an offer where if Mr. Cowart was willing to plead guilty, they would be willing to agree to the 769.4A status, as well as agree to I believe a likely term of probation, as probation would be necessary for that status. And I've spoken with Mr. Cowart regarding this case and regarding our options. He has indicated that he wants to accept that offer at this time. So we would be requesting the court to refer this matter to probation for that pre-sentence investigation report.
All right, may I inquire of your client of his advice of rights?
Yes, Your Honor.
Mr. Cowart, you understand you have the following rights, and I'm going to walk you through them, okay? You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have witnesses against you period trial, to question any witnesses that are brought against you. You are represented today by Attorney James Harris, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
Yes, sir.
You understand that you have the right to have the court order any witnesses appearing in your defense remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what was been stated on the record or threats that was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading guilty to the charge of domestic violence instead. Is it still your wish today to plead guilty to the charge of domestic violence?
Yes, sir.
All right. If you raise your right hand as best you can, do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
I'm going to bring your attention back to May 14th of 2026 at the offense location of 1136 Platt Street in the city of Lansing. Were you at the city of Lansing address 1136 Platt Street on May 14th, 2026.
That's correct.
All right. And who is Whitney Genty to you?
His mom.
So that's your kid's mom.
Yeah.
Okay. What did you do in relation to Whitney Genty that makes you guilty of domestic violence that was not done in self-defense?
She wasn't trying to leave my house, so I was trying to basically drag her feet, trying to get out of the house.
All right. So you offensively touched her.
Yeah.
Okay.
I ain't literally put my hands on her.
And you, so say that again, sir.
I ain't physically put my hands on her, like open hands. I just try to drag her out the house by her feet.
Say it again. I
Try to
don't.
get her out the house by her feet.
Yes, I believe I believe what Mr. Cowart was trying to indicate was that he didn't like physically assault or hit her, but he was grabbing onto her and dragging her by her feet, which I believe would be sufficient to consist as an offensive touch.
And she did not want to be touched at that time. Is that correct? Okay. So you weren't doing so in self-defense. You weren't defending yourself. All right. Anything towards the factual basis of Mr. Smith?
People are satisfied, Your Honor.
Mr. Harris.
Defense is satisfied, Your Honor.
I find the plea to the charge to be knowing, voluntarily, and accurately made, and will refer to probation. So the sentencing date, well, refer to probation is one floor down all the way to your right, and they'll do essentially they'll do a report for me. Really going to be looking at is the 769-4A status, because that's abstracted differently. So I'll refer to probation, and it is set, and we'll set the sentencing for August 17th at 1:30. All right, so we've set the sentencing for August 17th at 1:30. I'm going to refer you to probation, and we'll see what options are available to us on August 17th at 1:30. All right, sir? Anything else for the record in 26-01313, Mr. Smith?
Yes, Your Honor. I had an opportunity to speak with the complaining witness in this case, and I reviewed the pretrial conditions. One of the pretrial conditions is that the defendant was not to have any contact with the 3 minor children. This case does not involve the 3 minor children, and the complaining witnesses asked us to have the court remove that section of the pretrial prohibitions. So I believe she should be online if you need to speak with her directly, but I'm asking the court to remove that section, keep the no contact order in place for the complaining witness, but allow the defendant to have contact with his 3 minor children.
You have the P53 was set by Magistrate Milmore. Mr. Harris.
Yes, I believe the complaining witness should be here on Zoom. I believe it would be a Miss Whitney Genty. And the defense would have no objection to that, to the no contact order regarding the children being lifted at this time. If the court is willing to lift that, I would request that the court would perhaps permit third-party contact for purposes of child care for custody or for helping to establish contact with the children without having Mr. Cowart contacting Ms. Genty.
All right. Let's hear from Miss Genty.
And then I believe
Whitney Genty.
I believe Mr. Smith was on Zoom to speak with Mr. Ruiz if he's here.
All right, Mr. Smith, did you need to speak with someone?
Yes, Your Honor, I need to speak with Mr. Ruiz.
And Mr. and I can see them on the roller. Is he the Motorola or the Samsung?
It's not clear to me. I'll see if I can.
All right, on the Motorola Moto G, would you please identify yourself on that cell phone? On the Samsung cell phone, could you please identify yourself? Miss Genty, would you please identify, you can unmute? Whitney Genty?
Yes,
All right, and ma'am, you are Whitney Genty, is that correct?
yes,
It's my understanding that you are the prosecutors made a motion concerning the lifting of the no contact order involving the 3 minor children in this matter.
yes,
Did you have anything to say on that, ma'am?
no,
So did you want the no contact lifted?
yes, for the kids, yes.
And why was the no contact placed in the first place?
I have no clue. I thought it was supposed to just be for me, but turned out that they put it for the kids as well.
Mr. Harris,
Yes,
do
Your
you know
Honor.
why the magistrate placed the no contact with the 3 minor children? I see them. The only thing I can think of is that they're living at the residence.
That would be my guess. However, I'm not certain why a no contact order would have been placed regarding the children, given there weren't any allegations of child abuse or anything done involving the children.
I have that. So that would be, yeah, there's no allegations concerning child abuse other than the domestic violence occurred in front of the children. And then I have date of birth for the children are 2020, 2022, and 2025. Is that correct?
I believe so.
All right. Well, I'm going to lift the no contact order. In regards to the children, at the request of the prosecutor, but I'm going to keep it in terms of Miss Genty. 2, 3 minor children. No contact order is kept in place in regards to Miss Genty. All right, so the no contact order is lifted in regard to the minor children. You can see the minor children. It's still covered by whatever family court orders is out there. But you still have a no contact order in relation to Miss Genty. There was not a GPS placed on, so you're still under no contact order with Miss Genty, okay? All right, Miss Genty, thank you for your appearance today.
Thank you.
And so,
all right, good morning once again, everybody. TCF Live on a Monday. It's good to have you all here. So, Ashley and Barbara getting in on the Jules game. YouTube's been bugging me for months to turn that feature on, so I finally did. Ashley sends us a stay hydrated and a sunshine, and Barbara sends us a sandcastle, so thank you both for that. And Barbara gives us a $5 super chat and gifts 5 memberships. Thank you for that. Jonathan sends us a 100. Thank you. And my daughter just entered the chat. Good morning, Maggie. Good to have you here as well. It's a beautiful Monday. All sorts of good surprises. What is this boring channel? Well, Devin, if you find it boring, do please move along, because there's all sorts of places for you to go on YouTube and things to do, and I hate wasted time. So don't waste your time on us, my friend. Move along. Find something that entertains you. Lots of good choices out there. Alrighty, let's go to Judge Elmore. Say good morning to him.
Yeah, sit next to him. All right, thank you. He doesn't bite.
We're going to stop right here. Devin, you're banned. Move your miserable butt out of my world. And don't ever come back. Sorry, guys. Sorry, Maggie. Onward.
Yours already?
Not yet, Your Honor. Thank you, David and Helen. Behalf of the people, Your Honor. Thank you.
Robert Hartzell from Mr. Meekoff, who joined me on the left, Your Honor.
Right, you may be seated. All right, we're here today for sentencing in this case. It involves conviction for 2 and operating while intoxicated as a third offense, and possession of a firearm while under the influence. It was resolved with a couple pleas of no contest back on May 8th. One moment. Yeah, there we go. I knew I had something else. So review these earlier. All right, so also before we get to the pre-sentence investigation report, this court received last, I think it was Wednesday or Tuesday, a Catholic Human Services report on Mr. Meekoff, talking about or giving me an alcohol or substance use assessment. I read through that, made some notes and things like that. So I covered that last week, and also received by my office on that same day was a mitigation report for Mr. Meekoff. And normally I make notes, so give me just a moment. Oh yeah, because the Sarah Lee Bakery. All right, now I remember. And then attached to that were several letters. We have one from Dr. Deere, who is at the Lakeshore Community Counseling Center. Talking about its progress there. And there were some other statements or letters here that I received. And it looks like he's done a pretty consistent job here with attending AA classes. All right, let's turn right back here to the pre-sentence investigation report. Mr. Denham, do people have any amendments, corrections, or objections to make to the contents of that report?
Thank you, Your Honor. I have reviewed that report thoroughly, and I have no proposed corrections, additions, or deletions.
Great, thank you. Mr. Hartel, same question, sir.
Yes, Your Honor. We asked the court to consider on CFJ 145 under the term of probation, term 4.20, amending that just to no firearms. I do believe it would be appropriate. That way my client could still go bow hunting, things of that nature. We're not sure how much probation the court's going to give him, but I don't believe there are any allegations in the report of any bows being misplaced, anything. I do realize there were other issues the court may take issue with.
Which you said 4.20?
I believe that's the condition where it mentions no weapons, Your Honor.
Yep. All right.
I know the court sometimes has given that grace. I'd ask the court to consider it in this situation. Thank you.
Thank you. That's really more for allocution and mitigation. Mr. Denham, do you have any comment on that?
On that particular condition, I would simply leave it to discretion.
Copy that. Thank you. All right. Let me take a quick look. Anything else, Mr. Martell, as to the contents of the report?
No, Your Honor.
All right. Thank you. I'll just note here, I did go through obviously the CFJ 384 section. There were a couple of charges or cases for which he had some dismissals. Clearly, the court does not take those into consideration. And I don't think I had any other corrections here to make. All right, allocution. I'll start with Mr. Denham. Sir?
Thank you, Your Honor. First, the people, I guess I'll start out positive. I'm not aware of bond violations, any bond violations. So give credit to the defendant for that. I think that he's been performing well on bond. However, the defendant did receive a significant benefit of the plea agreement. We did dismiss the felony firearm count. I support the recommendation. The incident itself involved allegations, being on the lookout call. Allegedly, the defendant was all over the roadway. Ultimately, he was found at the local Wesco. He was somewhat non-compliant. When the blood draw was done, which was approximately 2 hours after the incident, so a significant period of time had elapsed, he still had a blood alcohol content of 0.239, which is, as the court is aware, about 3 times over the legal limit. So significant.
I think we need to let him finish out if you know.
Hold on just a minute. Go ahead, Mr. Daniel.
Okay, so significantly over the legal limit. There was a loaded gun in the vehicle. There were vodka bottles, at least 2. The PSI report notes that there's been a series of drinking and driving convictions in a relatively short span in the last few years. The defendant, I guess, reached my radar and of some concern on the 2024 incident, the failure to report an accident. That involved the defendant running into the backside of a manure spreader that was going 33 miles per hour at the time. He went into the ditch, went through the windshield. Witnesses indicated that blood was coming from his nose, and he was picked up from someone. So that raised some concerns for the people, given that scenario. He was not at the scene, so he was not charged. I'll leave it at the leaving the scene of an accident. But certainly that raised some additional concerns separate and apart from the OWI convictions. I do support the recommendation, Your Honor. I would respectfully request the court follow the recommendation of the probation department.
Mr. Hartel, did we miss something? Did there need to be a change?
Not that needs to be changed, Your Honor. My client may or may not wish to make a statement after my elocution. That's what he was informed.
Oh, okay, no problem. All right, thank you. Mr. Hartel, floor is yours.
Thank you, Your Honor. We also recognize that my client received a significant benefit from this plea. We realized there was an absolute minimum sentence as it was charged that would have sent him to prison. We're very glad that's not happening. He's cognizant of that fact here today. He is employed, as the court did note, at Sara Lee Factory. He reminded me earlier this morning, his shift is from 2 a.m. to 2 p.m. Quite the fun shift. I've done a few of those myself at different locations, or things close to them, maybe graveyard shift is my point. We would ask the court to fashion a sentence where he could maintain that employment and do the jail sentence on the weekends. We realize there's a minimum 30 days here, and the court can go above that. But I know sometimes the court does allow, with its grace, to allow my clients to do 48-hour chunks on the weekends. And even though I've informed him you most likely would want a GPS tether on him as you've done in the past, he would be willing to comply with that. He very much so wants to keep this job. He's informed me he has the support of his coworkers. He wants to continue to show them that he can be a good colleague, have his job so that he has good support structure when he gets done with the term of probation, that we don't doubt Your Honor will give him probation as well. He also continues to have the support of his family. I know some friends and family wrote letters. Others, I'm informed, still support him, but just didn't quite get the pen to the paper, but are definitely still there. They may or may not be watching right now, in fact. I would also ask the court to consider allowing him a week before starting any jail sentence so that he could tell his employer exactly what's going on. He was honest with them, he tells me, but because he didn't know exactly what the sentence would be, he obviously wasn't able to communicate that. So if the court give him a little bit of grace before the first day in jail, we'd appreciate that as well. As was noted a moment ago, he may or may not wish to make a statement. That's at his discretion. I've given him my advice on which things may or may not be best to say. I realize this was a no contest, so I won't overly allocute. I know the court has to take everything in the report as accurate, but because it was more for lack of recollection than civil liability, if he suddenly has better recollection, I just ask the court to factor that in. Thank you.
All right. Mr. Meekoff, you have the right to make a statement if you so choose.
I guess all I've got to say is that night was 35-mile-an-hour winds. It was windy. I hadn't drank until I was at the parking lot waiting for my ride to pick me up. Vehicle was off, and the person picking me up did speak to the cop on the phone. When he approached me, I was on the phone with them. I guess that's about it. Again, if I could somehow maintain my job, that'd be great. Or if not, I understand.
So, okay, I'm sorry, keep going.
I guess a week or so I could get my house arranged. That way I could let my landlord know that I'd be leaving the property or whatever.
Whose vehicle was this?
Well, it was my mother's.
How'd you get it?
I was working on it.
Okay. How do you get to and from work?
I get picked up by carpool. That my mom will take me to work.
How is that you remember this now and you didn't remember anything last time I took the plea 2 months ago?
I guess I didn't really quite understand everything.
What do you mean you didn't understand everything?
As in like the no contest or
I
whatnot.
explained it to you. I told you couldn't challenge what was in the report.
Right.
How was that? No, how was that not clear?
I guess I just wasn't. I mean,
You weren't being honest with yourself or with the court, because I'm pretty clear when I do a no contest plea.
Right.
You told me you couldn't remember. Which means if you try to tell me you remember stuff, I think you're lying. So I don't know. There is no better way to explain it than I do. I'm pretty sure I'm not patting myself on the back, but I say you cannot challenge what is said in here. And so I don't care if it was windy. You were obliteratedly drunk, swerving, putting people in danger. Whatever you've been telling yourself prior to sitting there in that chair today is wrong. Your hopes are not going to be met. You will be leaving through that door in about 4 minutes. You are not going to go to work and say, and give you another week. I don't know what the heck you've been doing in the last 2 months if you didn't tell them that that was a possibility. That does not matter. You are 31 and you have 3 drinking and drivings within 6 years. And in this instance, you were all over the road enough that people called police. You were driving when you could not drive a car. You were unlawful for you to drive a car. And it was unlawful for you to possess a firearm. Was that, am I right?
loaded firearm.
Yeah. No. Yeah, I'm not gonna let you go hunting. You can't possess a firearm. You can't possess a loaded firearm. And you were drunk with the blood alcohol level that would put most people in bed for a couple days, passed out. Oh no. I really hope what you told me was the truth. And if your mom's out there watching and she says, thinks to herself and she goes, well, I kind of let him have it, borrow it. It's her fault then that you got it. If she didn't, then that's not her fault. It's only your fault. So I don't want to be insulting to your mother, but I'll tell you, if somebody else was letting you drive their car, they were wrong. Had you killed somebody, it would have been on them too. Yeah. No. I appreciate you've been going to AA. That's great. Because you need it. Now, I'm also looking here, and there's some issues here about, depression and anxiety. I don't see any medications of treatment because apparently you are treating everything with alcoholism. And you began using at a young age. Age 17, 3 to 4 times a week in the last 13, 14 years. Wow. You set yourself up for failure.
Yes, Your Honor.
So, and I'll tell you why I talked about credibility, and that's what I jumped on right away when you started telling me about what you remember and then telling me I didn't do a good enough job explaining it to you. Well, you had a 3/4 empty bottle of Smirnoff in the car. But actually, there are 2 bottles. You lied to the cops about what you had been drinking. Failed 3 of 3 tests that were given to you. So again, 31 years of age, and your criminal history began about 15 years ago. Unlawful driving away of a motor vehicle and malicious damage of property. You were given a chance. Then you have this fail to stop at an auto accident. Then you have in 2019 an open intox in a vehicle and violence charge, although there's only an open intox for a conviction. Then in 2020, sure enough, open intox and drinking and driving. 2022, open intox and drinking and driving. And then 2023, driving a vehicle while your license was suspended, denied, or revoked. I'm not going to ask, and I don't want you to answer because it ain't going to go well. Boy, I would like to know whose car that was. And then in 2023, which was while you were on probation for the last one, you picked up another driving license suspended, which means deception. You're going to do whatever you want when you think no one is looking. And then 2024, oh my gosh, failed to report an accident and driving license is suspended, denied, or revoked. Now that charge was dismissed, but if you fail to report an accident, it doesn't take much. It's a logical conclusion that you were driving while your license was suspended. And I would love to know whose vehicle you were driving those times. Who's ever allowing you to drive their vehicles? It's too bad on them. And now here you are in about a year, and you've got felony firearm, R&O, which I know those were dismissed, the possession while drunk, operating while your license is suspended and not revoked, which I know that was dismissed, but I can tell if you were drinking and driving, you were driving while your license was suspended. So I've got deception, alcohol, and violence wrapped all under one here. So, yeah, it might be a good employee, but boy, I would never let you walk into my place of business or work without giving you a breath test every single time. So I appreciate that you're getting the help here, and that's great. And I'm going to help. So at the age of 31, you realize your days of consuming alcohol are without a doubt done. Because if you do it again and you get caught, your only next place to go is prison. And I would have no problem sending a 4th drinking and driver to prison.
Yes, Your Honor.
The court sentenced the defendant as follows: 36 months of probation. You have the right to be considered for early release from that probation at halftime if you are successful with the terms and conditions of that probation. The court adopts every single one of the terms and conditions that are listed in CFJ 145, pages 2 and 3. And I find that they're well suited for rehabilitative purposes. In this particular file, the court sentences the defendant to 12 months in the Missaukee County Jail, and he receives three days of credit. Court assesses a $68 state minimum fee for the felony, and there were two, and the other is a $50 state minimum fee for the misdemeanor, $130 crime victims' right fund fee, a $300 court cost, a $500 fine, and a $300 attorney fee for all the processing of this case from beginning to end. DNA fee was already available. Apparently, supervision fees are $30 a month or $60 a month if there's any electronic monitoring. So again, that's actually listed as 365 days. Okay. All right. Have I missed anything, Mr. Blazak?
I just wasn't sure if you were done with the second.
Oh, second, thank you. 93, I'm just gonna go 90 days of jail with 33 days of credit. Those two sentences run concurrently with one another. All right. Thank you. Anything else, Mr. Blazak?
No, thank you.
Mr. Denham?
Nothing further, Your Honor.
Okay, Mr. Hartel is going to bring you 2 copies of one document. You're going to place your initials on one copy. Doing so neither elects nor waives any rights. Based upon the plea, any appeal done in this case will be by filing an application for leave to appeal and not an automatic claim of appeal by right. Furthermore, if you wish to have the court appoint an attorney to assist you in an appeal, you may complete the bottom half of that document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. The number one thing you did wrong, the number one thing you tried to do today was try to tell me, oh yeah, now I remember, and I wasn't told well enough what was going on. I didn't understand. I don't believe you. Don't talk. You're going to make it worse. Just put your initial on that one page. The sentence is well within the guidelines. This is a straddle cell. The court could easily send the defendant to prison. And you're going to note one thing. Had I sent you to prison, you could have gotten boot camp. You probably could be out a lot faster than you will be when you're going that way. Thank you, Mr. Hartel. You can blame it on the wind.
My client has asked me to ask the court. I know the court.
No. Going to jail. It's not on weekends. You're going to jail. Blaming it on the wind, that was a bad choice. Thank you.
So I don't know why, but just now when he kept saying blaming it on the wind, I got Milli Vanilli's blame it on the rain in my head now. Hate when that happens. Good morning once again, everybody. It is TCF Live on this fine Monday morning, and it's good to have you all here. There's a lot of you here this morning, and I'm guessing that some of you are new. If you are, do please say good morning to us in the chat. We're a friendly folk, as long as you behave yourself, that is. Unfortunately, somebody earlier this morning found out that we don't tolerate people who don't behave. But I know that all of you that are left here are good people, so it is good to have you here. Let's do this. Let's go to Florida. Wade Mercer. Let's see how busy they were this weekend.
Yes, Lopez. Mr. Ricardo, good morning. How are you doing, sir?
Good morning, Your Honor. I'm well. How are you?
I'm doing great. Would you introduce yourself to Mr. Vasquez Lopez, please, and make sure he can see and hear you?
Yes, Your Honor. Muy buenos días, señor Vázquez. Mi nombre es Jordani Ricardo. Soy intérprete para que se pueda comunicar con el juez. ¿Usted me ve y me escucha?
Sí.
He can hear me and see me, Your Honor.
Great. Mr. Vasquez Lopez, you're here because you've been accused of one count of driving with no valid driver's license.
Señor Vázquez López está aquí porque tiene un cargo de manejar sin licencia de conducir válida.
You also have a hold from the Immigration Service.
También tiene una orden de retención de los servicios de inmigración.
You were set a bond this weekend and being brought back today to speak with an attorney.
Se le fijó una fianza este fin de semana y se le está trayendo de vuelta hoy para hablar con un abogado.
I'm appointing the Public Defender's Office to represent you. Please listen to Mr. McDaniel with that office.
Le estoy asignando la oficina del abogado de oficio para que lo represente. Por favor, escuche al señor McDaniel con esa oficina.
Your Honor, I spoke to Mr. Lopez. At this point in time, he's going to plead of no contest to the charges listed.
Su señoría, hablé con el señor López. En este momento, él se va a declarar no me opongo ante los cargos, tal y cual se le acusa.
Understanding he'll be sentenced to 3 days in the county jail with credit for 3 days and a $400 fine, which will be a civil judgment.
Entendiendo que se le va a condenar a 3 días en la cárcel del condado con crédito por 3 días y una multa de $400 que será un fallo civil.
Understands he has waived his right to a jury trial and call witnesses.
Ha renunciado a un juicio con un jurado y a llamar a testigos.
Understands any plea can't be used against him in immigration court.
Y entiende que cualquier acuerdo en un caso penal se puede usar en su contra en el Tribunal de Inmigración.
Nothing else.
Thank you. Mr. Mitchell, did you hear that agreement?
Yes, sir, Your Honor, and the state is in agreement to that.
Señor
Thank you,
Mitchell,
Mr.
escuchó,
Vasquez. I'm sorry, go ahead.
se escuchó el acuerdo, sí, su señoría, y el Estado está de acuerdo.
Mr. Vasquez, did you hear that agreement?
Señor Vázquez, ¿escuchó usted el acuerdo?
Sí.
Yes.
Do you have any questions about that agreement?
¿Tiene alguna pregunta acerca del acuerdo?
Los $400 que debo pagar con aquel. ¿O cómo le va a hacer eso?
The $400 that I need to pay, how is that going to work?
If you don't pay it, your driving privileges in Florida will be suspended indefinitely.
Si no lo paga, se le suspende su privilegio de conducir en la Florida indefinidamente.
It also will maybe sent to a collection agency and it may affect your credit rating.
Quizás se le envíe a una agencia de colecciones y le puede afectar su puntuación de crédito.
But you cannot go to jail for not paying it.
Pero no lo pueden llevar a la cárcel por no pagar.
Typically, I would suggest people deal with the
¿cómo le puedo
immigration.
hacer?
Un momento, por favor. I would suggest that you deal with the immigration issues and then worry about that later.
Yo le sugiero normalmente que primero se encargue de su asunto de inmigración y se encargue de los $400 luego.
Any other questions?
¿Alguna otra pregunta?
¿Y cómo lo puedo hacer? Porque el número de mi memoria no lo tengo en mi teléfono. Pero como le quitaron mi teléfono, no puedo sacar el número. Número ahí donde no puedo hacer nada.
And what can I do? I don't have any phone numbers that I know by memory. They're all in my phone, but they took my phone, so there's nothing I can do.
If your phone is at the jail, and if it's got power, the jail may let you use your phone to get a phone number.
Si el teléfono está en la cárcel y tiene batería, quizás en la cárcel le dejen usar su teléfono para sacar un número.
But you do have the right to use the phone this morning. You do have the right to use the phone this morning to tell family what's going on with your case.
Usted tiene derecho a usar el teléfono esta mañana para decirle a su familia lo que está pasando con su caso.
Any other questions?
No sé dónde estará mi teléfono porque la policía que me agarró ayer, él me sacó en la bolsa y él le echó en el carro otra vez. Ahí no sé dónde estará.
So I don't know where my phone is at. The cop that caught me yesterday, he took it and he put it in a bag. So I don't know where it's at.
Corporal, do we know if his phone is at the jail?
Oh, we're checking his phone right now. It is not listed on his property sheet, so I'll have to check and see if it's here or not.
Y Cabo, está el teléfono en la cárcel. No lo veo en la lista de propiedades, entonces tengo que verificar si está aquí en la cárcel o no.
Ah, bueno, no, está bien, entonces conté mi billetera, mi dinero ahí viene ahí en la billetera.
Also, my phone, my wallet, and my money is in there.
So, Mr. McDaniel, is there any, I'm trying to think of a reason. It's a sheriff's department case. There's no evidentiary value of the phone. And they may have it in their evidence area, I guess, but I can't think of an evidentiary value of the phone. Mr. McDaniel, Mr. Mitchell, anything?
Y
But
señor
they have to check to see if it's in his property. Sometimes it's in there, they just didn't write it down.
Y señor McDaniel o señor Mitchell, ¿ustedes saben de algún valor de evidenciario que pudiera tener el teléfono? No, señoría, solamente están chequeando si está entre las propiedades. A veces está y sencillamente no lo escriben.
I'm going to ask our Sergeant Applewhite here at the Sheriff's Department at the courthouse to contact the office, the Sheriff's Department's office.
Le voy a pedir al sargento Applewhite aquí en el tribunal que se comunique con la oficina de los alguaciles.
And if they have any property of yours, to take it to the jail and leave it there.
Y si tienen alguna propiedad suya, que se la lleven a la cárcel y la dejen allí.
Do you have any other questions?
¿Tiene alguna otra pregunta?
Creo que es todo.
I think that's all.
Have a good day, sir.
Que tenga buen día, señor.
Yeah, I don't think it took the plea yet.
Didn't take the plea?
We did take the plea.
You know what? I think I was in the middle of question. I asked him about questions before I accepted the plea. You're right. Go ahead and let him know that I'm going to go ahead and accept this plea now, please, Mr. Ricardo.
Bien, voy a aceptar el acuerdo.
I'm going to accept your plea of no contest to the charge of no valid driver's license, and I'm going to withhold adjudication of guilt on that offense.
Voy a aceptar su declaración de no me opongo ante el cargo de no tener licencia de conducir y le suspendo el fallo de culpabilidad en la ofensa.
Sentencing you to 3 days in jail with 3 days credit, court costs and fines of $400 to be a civil judgment.
Lo condeno a 3 días en la cárcel con crédito por 3 días y una multa de $400 que será un fallo civil.
Wish you the best, Mr. Vasquez.
Le deseo lo mejor, señor Vázquez.
Normally they would not hold that kind of evidence at the sheriff's department. It'll be taken to the jail. So maybe it's either at the jail, not on the sheet, or maybe the officer didn't do it for some reason. But my concern is him getting deported before he gets to contact his family. So they need to do it today if they can. The next case we have is Amari Leslie. Mr. Leslie, good morning. Mr. Leslie, you're here because you're accused of 1 count of driving while license suspended or revoked knowingly. Mr. Ricardo, anything else you have?
No, Your Honor. May I be excused?
Yes, sir. Thank you, Mr. Ricardo.
Thank you, Your Honor.
On that charge, Mr. Leslie, I have read the complaint. There is probable cause. I'm appointing the public defender's officer to represent you. Please listen to your attorney, Mr. McDaniel.
Your Honor, I spoke to Mr. Leslie. He's going to plead no contest to charges listed. The understanding he'll pay a $400 fine within 60 days, or he'll serve 10 days in the county jail. He has waived his right to a jury trial and call witnesses. That'll resolve this case this morning.
Thank you. Mr. Leslie, is there a chance you can get a license within that 60 days?
What would I need to do to get a license within that 60 days?
You had a very recent suspension. I don't remember what it was for, but it was a very recent one. I think it was recent. No, this was not that recent. Let's see what it says.
9/18/25.
I can tell you in just a second, but what I'm going to do is if you can get a license within that 60 days, I'm going to knock $100 off the fine. I would rather you spend that $100 getting a license than I would you paying it towards a fine, but you've got 60 days to do that. Mr. Leslie, knowing that, is this the plea you would like to enter?
Yes, sir.
Thank you. Mr. Mitchell, is this agreeable with the state?
It is, Your Honor.
Did you get the chance to look at it, Mr. Mitchell, and see what the suspension was for?
I just looked at the complaint. It's just talking about a non-judgment number back in September of 2025. I didn't see the exact reason it was suspended.
That sounds like it might be an accident without insurance, but I'm gonna look it up and see, Mr. Leslie, so I can try to tell you what the official driving record is showing.
Yes, sir.
Believe it or not, there are 4 Amari Leslies in the state of Florida. Let me see which one I've got date of birth here. There's 2 of them in 2002.
6/20.
There's 2 of them in June, but only 1 on the 20th. So let's see what we got here. Mr. Leslie, your driving record shows your suspension is based upon, you have 4 suspensions. Nope, you've got 3 of them fixed already. They were all financial responsibility, and the 4th one's financial responsibility. So what that means is some kind of insurance issue typically. So all you got to do is get that issue resolved, show proof of that to the clerk of court within the 60 days, and that'll save you $100. Any questions, Mr. Leslie?
No, sir.
All right, wish you the best, sir.
Thank you.
We have Troy Johnson next. Mr. Johnson, good morning. Mr. Johnson, you're here for first appearance accused of driving while license suspended or revoked. Offense, Mr. Johnson, there is probable cause in the complaint. I think the judge has already set you a bond this weekend. I'm appointing you a public defender's officer to represent you. Listen to Mr. McDaniel, please.
Your Honor, I spoke to Mr. Johnson. He's going to plead no contest to the charges listed. You understand he'll be sentenced to 10 days in county jail, 4 days jail credit, $400 fine. He has waived his right to jury trial and call witnesses. I think this is the one they got suspended a few days ago, but.
Yeah, and I think the only reason I suggested the jail offer in this case is because there was a warning the same day by the officer before he arrested him, and Mr. Johnson was allegedly driving again a few hours later. Mr. Mitchell, is this agreeable with the state?
It is, Your Honor.
Go ahead, Mr. Mitchell.
I apologize for that.
Someone started to say something. I was looking down. Somebody else was talking. Was that you, Mr. Mitchell, or someone else?
Yeah, I was coughing. I apologize for that. This is agreeable with the state.
Thank you. Mr. Johnson, did you hear that agreement?
Yes, I heard you, Your Honor.
Mr. Johnson, any questions about that agreement?
No question about the agreement. I do have one small question though.
Okay, go ahead, please.
When I got arrested last week, I know it might not matter to you all, but I got 2 service animals that I left my apartment. I had nowhere getting a phone call because on my phone, like the young man said, all my numbers are listed in my phone. I don't remember no. I got a case of short-term memory loss for taking some kind of medication. For the VA.
What are you asking?
Is there any kind of way I can get something done concerning my 2 service animals I left in my apartment for the next 5 days?
I'm having a hard time understanding you. 2 what in your apartment?
He left 2 dogs in his
2
apartment.
service animals, yes.
Oh, service animals. Okay. So what day were you arrested on?
Last Wednesday, the 2nd. I was arrested on the 2nd.
So the animals have been in your apartment since then?
Yes, I've been trying my best to talk to somebody about that, but nobody don't seem to care. Nobody don't seem to be able to do nothing for me. I don't have nobody's phone number outside. Is it possible I can go check with my daughter and come back and turn myself in for the next 5 days, make sure they be okay? I've been here a long time. I hate to see one of them is 5 years of age, the other just turned 2 months old.
What day was he arrested on, Corporal?
July 2nd.
July the 6th? Okay.
Or July.
Mr. Mitchell, what's your thoughts?
I'm not going no place, sir.
I mean, if the court is so
I'm sorry.
inclined, given the fact that the initial offer was 10 days jail and he's been in there for, let's say at the max 5, I'm okay with maybe a time served and we just do it that way.
No, the reason I'm not going to do that is if I do that, every time everybody I see is going to have dogs I need to take care of, Mr. Mitchell. That's just not a wise path to go down. What I will do is I will set your sentencing for 1 day later this week. And if you don't show up for that, I'm going to accept your plea. If you show up, I'm going to sentence you to the 10 days at that point and give you credit for the time that you've already done. If you don't show up, then we do get you. You've already pled, and sentencing is going to be at my discretion. So if you don't show up later this week, I can promise you it's going to be a lot more than 10 days unless you got a really good reason. Do you understand all of that?
I understand that, sir. I appreciate it very much.
Do you want to enter a plea of no contest knowing that your sentencing is going to take place? Let me see what's got me out here. Let's do it 1 day later this week.
You can do Wednesday.
Yeah, I know I got Wednesday's the day that I've got Judge Graham recovering.
Oh, that's right.
Bless you.
God is good.
Probably Friday. Mr. McDaniel, Mr. Mitchell, you're both going to be here Friday the 10th.
Yeah, no objection to Friday.
So what I'm going to do is I'm going to instruct you to, I'm going to accept your plea of no contest. I'm going to find it's pleading voluntarily entered. I'm going to instruct you to be at the Jackson County Courthouse for sentencing Friday, July 10th at 8:30 at first appearance. And what I'm telling you is as long as you show up on time, I'm going to go ahead and go through with this agreement. I'm going to sentence you to 10 days in jail. I'm going to give you credit for everything that you're entitled to, including today. And then you'll just finish the sentence. If you don't show up, then there's going to be a warrant issued for your arrest. And when I do see you finally, whenever that is, I'm going to sentence you to whatever I think is appropriate. And the maximum penalty for this offense is a year in jail. Do you understand all of that? Understand all of that?
I can handle that, sir.
Friday at 8:30, the jail will give you a notice for this Friday at 8:30, and I'll see you then, okay?
All right, sir. I appreciate you very much.
Yes, sir. We'll see you Friday. Have a good day, sir. So that takes care of Mr. Johnson's case. And that brings us to Ashton Gilley.
Or it looks like the camera that was on you just turned towards the TV.
Yeah, that's Dawn. She's always messing around with it. She doesn't like me being on camera. This camera makes my hair look thin on top. You ever notice that? It does. To be sentenced on, what's the date Friday?
The 10th.
7-10. So on your screen, you can't see me at all?
I can see you now. I can see you now, Your Honor.
All right, Ashton Gilley's next. Mr. Gilley, good morning. Mr. Gilley, you're here because you're accused of violating the terms of your pretrial intervention in 26-99 MM. Mr. Gilley, I'm going to appoint the public attorney's office to represent you and ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Mr. Gilley. At this point in time, we're going to plea of no contest to charges listed. You understand he'll be sentenced to 30 days in the county jail, 2 days jail credit, whatever the remaining fine is, and we'd ask the court to withhold adjudication.
Well, let me ask a question about the withhold, because the criminal history I've got this morning appears to show Alabama charges, which makes me believe either they're not him or it is him, and somehow it was missed when he was offered a PCI. So, Mr. Gilley, the question is whether or not I'm going to withhold adjudication of guilt, and the criminal history shows a 2021 charge in Alabama that's a public order crime. Dothan Police Department. Did you have that charge? Were you charged with something in Alabama?
Yes, sir.
Like a disorder intoxication or something like that? What was the charge?
I was caught with a firearm when I was young.
About to say,
But I had
5 years ago.
I already served it out in the
Maybe,
program.
how old are you? 2007, so you're.
Well, let's see. Based on his date of birth,
Yeah, he'd been 14 or 26, yeah, 19, so he'd been 14 years old.
yeah, you were juvenile when that happened. Is that right?
Yes, sir.
Okay, given that, I would still withhold adjudication of guilt unless the state's opposed to that for some reason. Mr. Mitchell?
We're not opposed to that, Your Honor.
And is this plea agreeable with the state?
It is, Your Honor.
And Mr. Gilley, is this a plea you would like to enter, sir?
So I do
30 days.
Yes, sir. Yes, sir.
Mr. Gilley, I'm going to accept your plea of no contest. I'm going to judge you guilty, withhold adjudication of guilt. I'm going to sentence you to 30 days in jail, but you have credit for some time you've already served, and that amount of credit is 2 days. I'm going to order the court costs and fines you did not get paid, which is $360 court costs and fines. Mr. Gilley, you certainly may do less than the 30 days based upon Florida's gain time laws. Hopefully you're going to get out there and at the jail, and you'll do some extra work at the jail and do less than 30 days. I know you're going to do less than 30 days. You may only do 28, but hopefully you're going to do less than that under Florida's gain time law. Mr. Gilley, you do have the right to use the phone, contact friends or family and tell them the case is over with, and you'll get to use the phone shortly. Do you have any questions?
Yes, sir.
Have a good day, sir. So, Mr. McDaniel, I know we have some jail cases. Is that it as far as first appearances go?
Yes, Your Honor.
Perfect. Let's move on to our jail case arraignments and pretrial. I've got a couple of short dockets for that. First case I have is State versus Deontay Bellamy.
Bernard Williams.
You want to take Mr. Williams first?
Well, those there we're going to be doing on Wednesdays, the ones you're talking about.
You know what? Yeah, there was some confusion about that because there was some we were going to try to do today, but some that may have had a private attorney we couldn't deal with till Wednesday. So Bernard Williams will be the first one today. Mr. McDaniel, is that right?
Yeah, yes, Your Honor. Your Honor, we're just going to ask to set this on the August 12th pretrial docket for Mr. Williams.
Is Mr. Williams in there, or have you talked to him already?
I've talked to him before, and he's in the jail. He's in lockdown. He's fine. He just don't like to put on clothes. I mean, he's obviously has some issues.
All right, Mr. Mitchell, you good with August 12th?
Is it just for a pretrial, or are we doing pretrial and trial?
Pretrial. He's not going to be competent. He's not.
I figured. Okay.
No,
No
you were saying
objection.
something, Don? Mr. Williams, you saying something? August 12th, then for Mr. Williams, we'll see him at pretrial on that day. Mr. Dixon, Ernest Dixon, case number 26316 MM. Mr. Dixon. And is this an arraignment or pretrial? I always have a hard time filling out these documents.
Arraignment.
This is a
It's
pretrial. So I've already appointed the public attorney's office to represent you, Mr. Dixon. Listen to Mr. McDaniel, please.
Your Honor, I spoke to Mr. Dixon. He's going to plead of no contest to the charges listed. The understanding he's going to be sentenced to 9 months in the county jail, 16 days jail credit, $370 fine. States agreed not to file any other trespassing charges against him as well. And that will resolve this case today.
I think that he has to what? So is he pleading to both trespassing and resisting in 316, Mr. McDaniel?
Yes, Your Honor. And
And the other case that's not going to be filed, you have a number on it, Mr. Mitchell?
Yes, Your Honor. It is MRV 26389.
And is this plea agreeable with the state?
It is, Your Honor.
Mr. Dixon, did you hear this agreement, sir?
Yes, I heard you.
Mr. Dixon, is this the plea that you would like to enter?
Yes, yes, sir. Yes, sir. Yes, sir. He said so. The other.
If you have questions now, I'll try to answer them. I just need to know if this is what you want to do or if you have questions.
Is that what you want to do?
Yeah, if that's what's gonna happen, right?
Yeah, that's what's going to happen.
All right.
I'm going to accept your plea of no contest, Mr. Dixon, in case number 26-316MM to the charge of trespass, other than structure or conveyance in resisting an officer without violence. Are they both first degree, Mr. McDaniel, or is the trespass a second?
They're both first.
First degree misdemeanors, judge you guilty of those offenses, sentence you to 9 months in jail on each case concurrent. Concurrent means they're running at the same time. Mr. Dixon, you got credit for 16 days. Also, I know that you're familiar with our trustee program. I don't see any reason why you shouldn't get in that program and get you some extra game time. Hopefully you will. There's no probation involved in this sentence. It's just a jail sentence. Mr. Dixon, 370 court costs and fines only imposed in count 1. The state is agreeing that they will not file on a separate trespass case they have received. Mr. Mitchell's put that case number on the record, so that case will not be charged against you based upon your plea agreement today. Mr. Dixon, do you have any questions?
Oh, sir.
Wish you the best, Mr. Dixon.
Judith Hamby, case number 26296.
Ms. Hamby's coming up for a pretrial in that case number, charge of 1 count of petty theft. Ms. Hamby, I'm appointing the public defender's office to represent you. Actually, I think I've already appointed them. Please listen to Mr. McDaniel.
Your Honor, so they got a pretrial in the violation of state probation case on July 9th. I kind of think it's probably going to getting taken care of at that point, but for now, we'll just put it on the July 20th trial docket and see where we stand. I, plan on, either trying it unless for some reason Jake has to set another date or something. But Jake, y'all got it set for July 9th, correct?
Yeah, we got it set for July 9th. That's a quick turnaround for a July trial. I'd rather, if the court's in agreement, I'd rather set it for the August, just so we might be able to get time to resolve both cases.
Tell me the July 9th is that a first VOP date or is that a hearing date?
It's a first VOP pretrial date.
Okay, why don't we do this? Why don't we bring her back on the 10th and see what happened on the 9th? And then I can decide whether I'm going to set it for trial in July or August. So Mr. Mitchell, my suggestion is if you want to go ahead and go forward with the VOP first, if you think that's going to be easier to prove, you need to get Judge Garcia to set that VOP hearing. It's a lot easier and quicker to have a VOP hearing than it is to have a trial. Otherwise, if she's in custody, Mr. McDaniel very well may have a valid basis to try to get this thing moved in July. So Ms. Hamby, we're going to see you on the 10th. We'll see what happened on the 9th. If the case is over with, if y'all resolve this on the 9th, I won't see you on the 10th. But if it's still pending, I'm going to see you July 10th at first appearance. Okay, Ms. Hamby?
Yes, sir.
Have a good day.
Thank you.
Yes, ma'am. We have Byron Polnitz. Polnitz is here. Okay, what about that's Ms. Kelly's case. Okay. So Mr. Polnitz is Ms. Kelly's, Mr. Tyndall's Ms. Kelly's, and Mr. Bellamy.
Maybe mine, I'm not sure.
So he's saying he's had a private attorney, but that private attorney's not filed a notice of appearance, but that private attorney did appear at first appearance.
Yeah, he appeared at first and said he was going to be representing him, said he was coming to talk to him. So I don't know. I don't know if he did or not.
He's not filed notice of appearance in either case. Okay. So let me see what that, while we're here. The offer on Mr. Bellamy was 6 months in jail. Mr. Polnitz is 4 months in jail, and Mr. Tyndall is 9 months in jail. That was the offers on those three. So whatever judge is covering, I think it's Judge Grammer, just let him know that I had approved those offers. Whatever the judge decides is appropriate. That's his or her decision, Mr. Mitchell, but it is what it is. Anything else from the state today, Mr. Mitchell?
Nothing from the state, Your Honor.
And Mr. McDaniel, anything else from the public defender's office? All right, ladies and gentlemen, that concludes first appearances and our pretrial and arraignment docket for today. Corporal, anything else from the jail staff today?
No, Your Honor.
We do.
All right, that's it for Judge Mercer this morning. It's TCF Live on a Monday after a nice holiday weekend. I hope you all had a good weekend, by the way. We did here at the bunker. Not relaxing necessarily. We did a lot of work, but it was productive. It was a good time. Let's do this. Let's go to Texas. Say good morning to Judge Stevens.
Daniel LeBlanc, 24 CR 520.
Your Honor,
the state is present and the defendant is present with his attorney, Mr. Kimmer. Go ahead.
I related an offer to the defense of
time served for a misdemeanor conviction, and I understand that's been rejected. If that's been rejected, that's fine. I just want to make sure I give him one last chance before I do this.
Just not sure what's our terrorist.
Terrorist, yeah.
She can't.
I'm sure.
You just give mom.
Oh, it's rather large.
Certainly, yes. He's indicted for a third-degree felony, right?
Yes, sir.
Okay. Okay. That carries with it up to 10 years in prison, but he's eligible for probation if he was found guilty.
If you don't want to get out.
Yeah.
Yeah.
Yeah, he's been pleading not guilty, so.
That's what I'm saying.
Then Judge, with that, I'll withdraw all offers after that. So we're not. Let's try it.
Okay, everybody hears that. Okay, then that will be a ready here.
Yes.
Jason Altman. John West.
Judge, I'm ready for trial 6.
I'm sorry.
I'll try 24-608.
That's a possession control.
He's habitual, so.
All right, Darren Patterson, Mr. Burbank.
Which Patterson's writing is the.
What do you want? You're ready?
We're ready, Judge. I only represent him on the gun charge.
Yeah.
Trying to get him, but I am number one.
Who said you were number one?
Huh?
Who said you were number one? Was that a vote that was taken?
That was a vote.
Was that people had sent in letters and?
Oh,
John didn't. John says he didn't vote.
I think I need to sit down on this one.
Which one do you represent him on? I am
He's done, Joe.
What's the, I haven't told her the gun charges. Is there priors or anything? No, there are.
I didn't hear what you said, Judge.
Are there priors on that? In that indictment? What?
Oh, you said in
How many? One enhancement.
I don't know if it's what she said.
Yes, sir, just one.
So it's a third degree enhanced to a second? And he's not eligible for probation, I guess. With the prior.
He votes for 2 years.
And he knows that. Okay.
And if everything falls through, Judge, I'll be ready on that.
Okay. There's going to be some others that are going to be ahead of y'all, but I want to set it briefly forward, just not far in advance.
Whatever date you need then.
It's 4 weeks good?
Yes,
For
sir.
everybody? Okay, let's set this, try to get this tried on in 4 weeks, okay? And it's the possession of a firearm charge that the state's going to go.
Yes, sir.
Okay.
Judge, can we find out who represents him then on the possession of a controlled substance? Or is he planning on?
I was planning on.
Oh,
What do you say? He's mobile.
he's not represented on the possession of a controlled substance. He's supposed to be hiring Burbank, but he has not hired him on that other charge.
We might have come to a meeting of mine.
It's 2 years old. It's about time you hired somebody, but that's okay with you. We're going to move forward without it. If you don't have a lawyer, you can represent yourself. You've had more than enough time to hire somebody, sir. We're going to move forward in 4 weeks trying this thing. Okay, the special
Yeah,
set.
I'll be ready.
Aaron Traylor, John, where?
Yes, we're ready. We should talk about it quite a bit. Yeah.
Ricolby, Washington. Yes, sir.
They're gonna announce it.
When are you going to be able to try it?
They have about 6 weeks. I've got to take care of it.
You see here.
Was Watson? I saw him in the hallway. He is here. I can grab him.
Ricolby, Washington.
No answer in the courtroom.
I don't mind giving Charles some time, Judge.
Okay. What are we gonna do on Patrick Winston?
Judge, I'm hired on that case and all.
Okay, hold on.
I just wanna, and he's here.
Well,
he needs to be in here. Where is he?
He'll come to the door in just a second. I saw him.
Should we have a musical introduction?
You see if I think so. There is Mr. White, you are.
Come on up. This is where the action is, sir. You gotta be in the courtroom. You're Racoby, Washington, correct? You have to speak up. And yeah, this is the way it works. We don't use sign language. You're charged with several serious crimes here, but let's get sit understood which one we're going to be going on, okay? Because you got four, and we're going to reset this, but we're going to set it for a specific time, and it'll be tried on that day.
Yes, sir.
And then we'll go to the next one, and the next one after that. 1713 is second assault of a child with second degree felony.
These all arise out of the same fact and circumstances, so I will likely try them conjunctively, Judge.
That is just that's not discussion. And discussions are going.
Okay, so there are 3 second-degree felonies which carry each one up to 20 years in prison, and then a third-degree felony and 1716. That's 10 years. So you're looking at a total of potential exposure of 70 years in prison, up to 70 years in prison on all this. And y'all are going on the sexual assault child?
I'll probably go on all at the same time, Judge.
I understand.
I will file a motion to consolidate and to stack the sentences if it happens.
Same complainant?
Yes, sir.
Yes, sir.
Okay.
As I said, we have ongoing discussions about it.
Discuss all day long. We're trying the case.
Yes, sir.
What's this? We're going to set it on a particular day from today. What's good? Give me how many weeks? Is 6 going to be good? 6. Okay. Set it specially set 6 weeks, and the relationship of the child to this person is
no relationship,
because you can't have any contact with that person nor anyone on your behalf. Let me speak. You can speak afterwards. She can't take when both people are speaking. She can't take it. Although she can do great things, but that's impossible to do. More than one person speaking at one time, and she has to, by law, take down everything that's said. Anyway, it would be inappropriate, plus it would be catastrophic to your bond, either through both your bond, if you find out you or someone on your behalf are trying to influence her or communicate with her prior to this cause. Understand? You know what that? Sitting there, waiting. Sentencing. That's a coincidence. What are we doing there?
He's here.
Okay, what are we gonna do, Langston?
Just, so.
It's TCF Live on a fine Monday. We're about halfway through already. Time flies. Let's do this. Let's cross the hallway. We'll say good morning to Judge West. Monday morning fashion show time.
And Mr. Hingston, did you get someone hired?
Ashton, Russian Norman, and Ralph Campbell. Just a little too high right now.
Are you working?
Yes, ma'am.
Where do you work?
JP Fulfillment Warehouse.
Okay. If you want, I can have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer, or I can give you one more reset to see if you can hire someone. I don't, with your income, I'll just have to take a look at it to see if you qualify, but if you want to fill out that paperwork, I'll let you.
Out of Langston, so I might be trying to hire
All right, well, you've been coming a few times now, so you need to try to get him hired before that next court date. If you get Mr. Adams hired, bring the reset notice to him. If for some reason you're not going to be able to, talk to some other attorneys, also bring a pay stub and we'll get you to fill out that paperwork next time. All right, step in front of the clerk. Terrence Jenkins. Good morning, you're Terrence Jenkins?
Yes.
And Mr. Jenkins, did you get someone hired?
Several people. So Williams Law Firm said they're charging 10,000. Walker Law Firm to me is charging 15,000. Franklin said they're charging 10,000. I got them 7,500 Frank, and so good Parker side I got them 2,500.
So
I'm not working right now. The job I was supposed to get, my background didn't go through, so I couldn't get hired. And I'm waiting on the HR to call me from my old job to see if I'm eligible to be hired for the charges.
I'm gonna have you, thank you for doing what I asked you to do, Mr. Jenkins. I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely because you're gonna swear under oath that it's all true and correct, and then I'll take a look at it. You step in front of the clerk on the end, she'll give you that paperwork. David LeBlanc. Good morning. Are you David LeBlanc?
Yes.
And Mr. LeBlanc, this is your initial appearance. Can you hear me?
Yes.
This is your initial appearance in cause number 26 DCCR 0644. You're charged with a third-degree felony offense of theft of property, and that's from July 21st of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I've just talked to my lawyer Friday,
Okay, who's that?
Ralph Kindler.
Okay, and you're going to hire him on this case?
Yes, ma'am.
So what I'm going to do is reset your case about 30 days to give you some time to get Mr. Kimler hired. If you do get him hired, make sure you bring the reset notice that you get today to his office and they'll tell you what to do. If that's not going to work out for some reason, then you need to talk to at least 3 other attorneys before that next court date and bring me those names so that I know you're trying. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you would go back to jail. Do you understand?
Yes, ma'am.
All right, step in front of the clerk. She'll give you a reset notice. Tyler Douglas. Tyler Douglas. Tyler Douglas. Tyler Douglas. This bond will be forfeited for non-appearance and reset at 100,000. Kyle Whittington.
Good morning.
Good morning. You're Kyle Whittington. And Mr. Whittington, you're here in both, in 2 cases. Did you get someone hired?
Sunny Accurate was the one we're actually shooting for still, but like I started off with this new job, like this hot shop business, and it takes a little bit of money to actually like start it up. So like I've had to put a lot of money aside so I can get the money I really need to actually be able to hire them. So like it's gonna take a little bit more. I can go for like, you know, a public defender right now, but I'm gonna probably replace them eventually with Sunny Accurate.
You're working now?
Yeah, like I'm doing hot shots, like I'm basically running trucks, like, you know, across Texas, like, you know, loads and stuff like that, and I get paid like by the basis, like weekly.
All right, so I'm going to reset your case one more time. This is going to be the last reset. You need to try to get Mr. Eckert or someone hired before that next court date. If it's not going to work out with him, then make sure you talk to some others, bring me those names, and bring me any information you have with regard to income as well. If you don't get somebody hired. Step in front of the clerk, she'll give you a reset notice.
Tim, thank you for gifting 5 memberships. I appreciate that. Also, YouTube's activity screen for me was a little bit on the fritz earlier, so I missed some of this. But Jonathan, Barbara, Lindsay, Silliest of Geese, Carolina Sunshine, you all gifted jewels. Thank you for that as well. I appreciate it. Let's stay with Judge West for a little bit.
Yays, but. Okay. And Brittany's doing Wilkerson's.
Well, maybe we won't stay with Judge West. Looks like she's taking a break. Let's go back up to Michigan. Judge Elmore has a new contestant.
Courtroom, and is now seated. We're here today for a sentencing including 3 charges, 3 convictions for felons. Plea was entered back on May 8th of this year. Mr. Denhousen, any amendments, corrections, or objections to make to the contents of the PSI?
The people do not.
Mr. Champion, the same?
Then, Your Honor, I was going to object to OV 10, but in further research, it is scored appropriate.
All right, thank you very much.
Could not have doubted the probation.
It's okay. All right, thank you very much. Let's turn over to the people. Oh, wait, hold on. I will note that I went through the report and I did not have any notes for any potential corrections. Thank you. Now, Mr. Dunham, allocution, sir.
Thank you. Your Honor, the defendant, as the court is aware, pled guilty to 2 counts of aggravated CSAM and 1 count of using a computer to commit a crime. Recommendation is as indicated, credit for 132 days. The defendant does have a significant prior history involving minor victims. This incident involved late last year, the law enforcement receiving a tip that there were from a internet provider that there were CSAM downloads involving young children, bestiality, and infants. There was a search of the defendant's home. He was cooperative. His phone was seized and the CSAM was confirmed. The defendant himself was identified. Defendant did acknowledge he did enter the plea in this case. We believe that the recommendation is appropriate and we would respectfully request that the court follow the recommendation.
Mr. Champion?
Your Honor, this is an unfortunate situation. Mr. Shepard, as the prosecution stated, has accepted responsibility. He understands this is an issue that he needs counseling with, and with that, we leave the rest of the discretion of the court.
Thank you very much. All right, Mr. Shepard, you have the right to make a statement. Is there anything you wish to say at all today, sir?
No, sir.
Thank you very much. All right, well, what the attorneys have said really covers it well. One might think and say, well, they didn't say a whole lot, but they hit the highlights. There are some convictions here that involve young people here and past. We also see a theft case involving a larceny in a building, and we see some prior criminal sexual conduct convictions back in 1998, 2001. Okay. 2002, another criminal sexual conduct in the 3rd degree. Sorry for my pause. I was just looking to make sure that there wasn't any status of events change that we needed, but I can see why they're not listed. But anyways, now we had also a CSC 3rd degree in 2000, or a couple in 2004. So quite clearly there is an issue, as mentioned by the council, involving the defendant's activities with young people. Here is basically just possession of child sexually abusive material, which we basically know as meaning child pornography here. And the court, while recognizing that the guidelines 87 to 145 as a minimum. The court is limited, as acknowledged inside the report, by the 2/3 rule, which is actually a statute handed down by the legislature. Therefore, the court, not needing to find any substantial compelling reasons to deviate from the guidelines, but actually to say, I'm not allowed to go any higher than the sentence the court will give. For counts 1 and 2, the court sentences the defendant to 80 to 120 months. Again, that is below the guidelines, but it's actually not when you consider the limitations placed on the court by law. As to count 3, which is the use of the computer, the court sentences the defendant to, and I'm just going to go 48 to 120 months. That is within the guidelines. It's right in the middle. And these convictions will run concurrent with one another. Have I missed anything? Oh, wait. $3 $68 state minimum fees, Tina. Okay. One $130 crime victim right fund fee. I'm not going to assess any other court costs, attorney fees, or fines, as collection would be most likely ineffective. Have I missed anything, Ms. Odell?
Your Honor, did you mention jail credit?
Oh, 132 days, right? Yeah, 132 days, Tina, for each one of those 3 offenses. I apologize. Thank you, Ms. Odell. Ms. Odell, anything further?
No, Your Honor, thank you.
Mr. Denham.
In the same count for both aggravated possession of police and, Your Honor, just for clarification. The same sentence for both?
Yes, counts 1 and 2 have the same sentence of 80 to 120 with 132 days of credit. And count 3, using the computer, is 48 to 120 with 132 days of credit. Now, Mr. Shepard, what you are receiving from the defense counsel, Mr. Champion, is 2 copies of one document. You are to place your initials on the first copy. Doing so neither elects nor waives any rights. It merely acknowledges your receipt of that copy, of the other copy. This document tells you that you have the right to appeal the conviction and sentence in your case. That's typically done by filing a claim of right to appeal. However, based upon the plea in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of that document and return to the court within 42 days. All right, Mr. Shepard, the way you've handled this case, pretty upfront, and I appreciate that. These are not victimless crimes because somewhere out there, there's a young person whose images were taken. But I think it's a fair and appropriate sentence, plus it's according to the law. Anything else, Mr. Champion?
No, Your Honor. Thank you.
All right. Thank you. We're adjourned.
All righty, Judge Elmore made short work of that. And that's probably a good thing. I don't think that needed a lengthy explanation on the part of the defendant. Let's go back to Judge Stevens, new contestant approaching there.
All right, we call 26 CR 293, the state of Texas versus Leslie Kurt Foreman. You're Mr. Foreman?
So,
And you were here with Mr. Adams, your attorney, and the state's attorney. I'm looking at this file here. And this is an indictment charging you with failing to comply with sex offender registration, which you've only been convicted 4 or 5 other times of that. So you know that it's got ramifications. It's got requirements because you've been convicted failing to register in 2004 out of Faulkner County, Arkansas. Failing to register out of Faulkner County, Arkansas in 2009. after that 2009 conviction was final, you committed the offense, it says, of failing to register and were convicted of that felony in 2011. After that was final, you were convicted of failing to comply with sex offender registration for life and were convicted of that in 2020 out of Bowie County. You've been an habitual felon at least three convictions ago. So you're looking at 25 to life. You understand? All right. That's just so you know. And this is what this alleges is, once again, you're accused of failing to comply with sex offender registration in this county. And so you're not eligible for probation, and your minimum sentence is 25 years to life. Do you understand all of that?
Yes, sir.
All right. So what else? Did you want to put something else on the record?
Yeah.
Go ahead.
Yeah, just the offer in the case is 10 years. He is aware that he's habitual, looking at 25 to life. He did not want to place the case on the trial docket. I think that he needed a little bit more time to digest the offer and just wanted one more announcement, but he did not want to reject the plea offer, and he did not want to set it on the trial docket. I think he had some affairs that he needed to get in order. So that's what he was asking for. But I did.
Well, he doesn't work on his timetable. I mean, this thing's been indicted since February 16th.
I didn't know what the.
It's going for it's 5 months old right now.
How about start 2 weeks then? Just two.
I got one.
One is perfect. We can, we'll take that. One will be fine.
All right, you've had more than enough time to think about it. You had 1 week.
Thank you, Judge. Appreciate you. Thank you. I'll live in. Right.
Alrighty, looks like Judge Stevens is going to take a moment. Let's do this. Let's go to Louisiana. Let's check in with the board. It's a 4-person board this morning, which means they're probably doing pardon hearings, but let's find out.
To order. Today is Monday, July 6, 2026. The time is 9:03 a.m. We are at DOC headquarters in Baton Rouge. Would you call the roll, please? Renata. Here.
Stapleton.
Here.
Prater.
Here.
Dennis.
Here.
Freeman.
Here.
Madam Chair, we have 4.
All right, thank you. Our first, we will allow public comment before any action item is considered. Our first item under regular business this morning is review and approval of the minutes from our Monday, June 22nd, 2026 regular meeting. Those minutes are included in your packet. Are there any corrections? All right, hearing none, I'll entertain a motion for adoption.
Second.
We have a motion by Mrs. Stapleton, second by Mr. Freeman. Is there any objection? Hearing none, the minutes are approved. So we'll move right into our consideration of applications for clemency or pardon. And our first case this morning is Mr. Vines, and we are at the Southwest Correctional Center. Would the staff there please introduce yourself for the record?
Kelsey Benoit. I work in admin. And Mr. Vines has no write-ups. He's a good man. I work also visitation, and every weekend his family comes. He'll have good support if y'all were, to let him have the parole. His son and wife, they're very sweet people, and they're always there for him every day right at 1 o'clock. So other than that, he's a good man.
All right, well, thank you, Ms. Benoit. First, Mr. Vines, I need to read some identifying information into the record. You're here before the Pardon Board this morning. You're seeking a commutation of your sentence. You were sentenced in Ouachita Parish. December 23rd, 2014, an 18-year sentence for manslaughter conviction. Is that information correct, sir?
Yes, ma'am.
All right, thank you. We have a room full of guests here, but your case this morning has been assigned to Mr. Freeman, seated to my right. I'll just turn it over to him. He'll take the lead.
Okay, first I'm gonna read out the people who are here. If I miss one of your names, let me know, and we'll get to you at the proper time to allow you to speak on Mr. Bond's behalf, and also for the victims to let us know their feeling. So on the side of Mr. Vines is Brittany Vines, his wife, Jonathan Kirkland and friend, Christopher Miller, pastor, Ron, all three of those will be speaking. Here in support but not speaking is Ron Lowe, grandson-in-law, Jessica Kirkland, a friend, Janalen Allen, a friend, Terry Hamilton Vines, son-in-law, Amber Hendricks, friend, and Michelle Wade, son-in-law. Did I miss anybody? Okay. On the other side, we will have Miss Natalie Todd, the victim's ex-wife. She will be speaking. Mark Todd, victim's brother. He will be speaking. And then we have Carter Cagle, victim's nephew. Morgan Todd, victim's niece. Josie Todd, victim's niece. Parker Todd, his son. Kathy Todd, victim's mom. April Todd, sister-in-law, and Peyton Todd's son. Did I miss anybody on that side? Wait. Okay, what's your name, sir? Terry. Oh, you gonna be speaking? Okay, and then y'all the two that's gonna be speaking, correct? Three. Okay, and your name, sir? Peyton Todd. Peyton Todd. Yes, sir. Okay, let's get on with the proceeding. Okay, Mr. Vines, tell me, what did you do to get yourself put into this situation? Tell me exactly what happened. I read the case, so be honest with us. And what have you done since you've been in that we should consider asking the governor to pardon?
What got me here was a series of events that spiraled way out of control because of bad decisions, impaired judgment, and irresponsible actions that resulted in a great tragedy where I took a man's life, Mr. Corey Hunter Todd's. And that's what got me here. And you asked what I have done since I've been incarcerated?
Sure.
Okay. Well, basically, I've done a lot of reflecting and trying each day to become a better person. I've taken self-help courses. I have came to the conclusion that while I know that I owe society on one hand 2 years and 10 months more of being incarcerated. But in reality, in my mind, I owe society the rest of my life of being a productive member in that society because of the teenage years and in my 20s, I was somewhat of a prodigal who had resources to be something, and I misused those resources with irresponsible behavior. And I feel that is the true debt that I owe to society, is to somehow counteract that with being a good man, a husband, a father, and living the rest of my years on this earth as a law-abiding citizen, not one that creates middle ground in between right and wrong, but only has one line. It's either one or the other. And where I used to create that middle ground, I see that was one of my faults, one of my many faults that I had. And basically, I've reflected I've made a goal each day to be a better person than I was the day before while incarcerated. And I have suffered greatly too. And I feel that the desired results of my incarceration have been achieved.
All right. I might have some specific questions to ask you later. But now we're going to get into the people that are here to speak on your behalf. Miss Vines, Miss Brittany Vines, y'all can go in any order y'all want, but I have you first. You want to go first?
Good morning, and thank you for allowing me to speak today. My name is Brittany and I'm Sean's wife. I just want to share with you what I've seen over the last 13 and a half years. First, I want to acknowledge that nothing I say today can undo the tragedy that brought us all here. I know that another family suffered an unimaginable loss. Nothing I say is meant to diminish that loss or your pain. And I recognize that no decision made today can undo the past. What I can tell you is that the man that you're looking at on the screens today is not the same man he was 13 and a half years ago. After that night in 2012, we knew our life had to change. And long before Sean was incarcerated, we walked away from alcohol, bars, and the lifestyle that led to so many poor decisions. During one of the hardest seasons of our lives, God found us and started building our lives. We became members of the assembly in West Monroe, and Sean served on the church media team and started intentionally surrounding himself with faith-filled men for men's groups, seeking to better himself in the direction of his life. Today, I'm still an active member of our church and serve on the women's ministry team. Our church family, along with our family and friends, have walked with us through every step of this journey, and they've encouraged us, supported us, and stood by us through the hardest years of our life. I know that they will continue to be that support when Sean comes home. This has not been a temporary change. This has been our life for more than 13 years. Our son was born just a couple of months before Sean was incarcerated. And even from prison, Sean has done everything that he possibly could to be the best husband and father that he could be. I've had a front row seat to his life and his growth, and I've watched him become a man of faith, humility, responsibility, and integrity. Throughout his incarceration, Sean earned the trust to serve for years as both an honor inmate and a trustee. And those are not positions that are simply given. They're earned through consistent behavior, responsibility, and trust over time. Hindsight is a powerful thing, and it teaches us lessons that we wish we had known in the moment. But it also becomes a lifelong burden because you never stop looking back and wishing that you could change how everything unfolded. Sean will carry the weight of that night with him for the rest of his life. And that type of pain does not disappear with time. And to know Sean's heart is to know how heavy that burden of pain will always be. When Sean comes home, he will be coming home to a stable home, a loving family, a church that has been walking beside us for years, and a job waiting for him. He will be surrounded by people who love him and will continue encouraging him as he rebuilds his life at home. Today, I'm simply asking that you look not at only one tragic night, but at the last 13 and a half years that have followed. Those years don't erase what happened, but I do believe they show the man that Sean has become, and I've had the privilege of watching that transformation with my own eyes, and I respectfully ask you to consider giving him an opportunity to come home. Thank you for your time.
Thank you for coming to speak to that. Okay, now we'll have Mr. Jonathan Kirkman, employer and friend.
Thank you for the opportunity to speak. For April of 2025 to around November of 2025, I had the pleasure of giving Sean Vines the opportunity to come work with me and my company. And through that short amount of time, I saw a man that showed up every day with a good attitude, positive, very good work ethic. He learned very quick. He humbled himself and allowed me to teach him everything I knew so that he could, in return, do his job to the best of his ability. Not only did I see that in him, but I saw him invest time and his knowledge in the guys that work with us as well. Anytime that we had a new guy come on staff work, Sean was always there quick to teach them and to help them grow as well. I saw a man with good character, love for the Lord, and respect for the leadership that was placed in his life at that point in time. And one thing that I can promise you that he's coming home to is an opportunity to work in a company that gives back to our community, that pours into those that choose to be with us. And I will make sure that he continues to have an opportunity to work to better his family and to do good for many years to come, and to build a career that maybe he can pass down one day to his family. So thank you for your time.
Appreciate you also coming today. All right, Christopher Miller, pastor.
Yes, sir, I'm here.
Okay, what do you want to tell us today about Mr. Vaughn?
Yes, sir. My name is Pastor Christopher Miller, and I serve as the lead pastor at the Assembly in West Monroe, Louisiana. And I've been in the pastorate now for over 20 years. Whenever I met Sean and Brittany in 2012, I was serving as an associate pastor at the Assembly West Monroe shortly after the incident involving Sean. It wasn't long until I invited Sean and Brittany to be a part of wife and I's young married couples connect group at our home. It was this time with Sean that gave him spiritual counsel and assisting him with his relationship with Jesus, which set Sean on a path of recovery and discovery of who he is being called to be in Christ. Having served as a prison chaplain, as a side note, I know what jailhouse religion looks like, and I've worked with men who have only turned to God in hopes of playing the religious card to soften punishment. But this man, Sean Vines, in my personal opinion, because of my personal experience, he has the real thing. Sean and Brittany got married, joined our church, was faithful to our small group, to our study, and was blessed with a baby boy. My wife and I had dinner with the Vines on numerous occasions, saw them flourish in their marriage as well as in their relationship with Christ. And I've seen them become a vital part of our church, even as Brittany made reference earlier. Even after Sean's incarceration, she continued to serve and has been faithfully involved in our church since then. During my times with Sean, whenever we would talk about what happened, all he could speak about how is he wished he could take it all back. This was a man that was truly remorseful and sorrowful for his actions, and had sincerely asked the Lord to forgive him for taking another man's life. Sean has been a man who was once plagued by vice and sin, but as he made reference earlier, that his life has changed. He's now a man who loves Jesus, loves his family, loves his friends, even to the point where I've sent him my sermon notes for him to be able to be resourced in his journey of faith. To further validate this point, I made it a point several times to visit him during his incarceration, both accompanied with his family and visitation with his wife and son, as well as individual visitations myself one-on-one personally. Ms. Brittany has faithfully attended our church, as she made reference earlier, from that day until now, along with her son, and they're both actively involved in our faith community at the Assembly. Brittany is one of my wife's closest friends and is a dear friend to our family. And we have, as Brittany made reference to, walked with this precious family from the beginning of all of this terrible tragedy up until now. And it's from that place that I feel the assertion that I can make the claims and the assertions that I've made to this point. I love this family and I care about them. I care about Sean. It is from this place that I sincerely request a consideration of clemency and that he be granted his freedom. It is my opinion that he's paid his debt to society, and with this clemency, this man will be given the opportunity to build a future for himself, his wife, and his son. I'm asking you to free this man so that I can pastor this family as a whole, to walk with them, to help them to rebuild, and to be able to move forward and to be able to shepherd their souls as Christ helps me. I'm asking for mercy on behalf of Sean, but also for his son, Bo Drake, who is one of my son's best friends. This son needs his father, this wife needs her husband, and he needs his freedom to meet those needs. Sirs and madams, I ask you more directly, apart from expressing my views of Sean for just a moment. I cannot begin to understand, nor would I claim to understand, the burden that each one of you are shouldering as you sit in the seats of authority within the justice system managing clemency hearings. And I'm sure that you've heard it all to this point. With that said, you also shoulder the weight of holding the power of freedom or imprisonment within the declarations of your judgments to move forward to the governor. This weight I cannot fathom, but as a shepherd, I too bear a burden of society as well. I too understand the burden of authority because I must bear that weight to my church family as I shepherd my people and lead them in the matters of faith and the scripture and godliness. The Bible tells me to honor those who are in leadership in matters of law and order and to respect those who are in authority. The Apostle Paul tells us that in Romans 13, verses 3 and 4. It says that as servants of God, that you do not bear the sword in vain. In closing, the Apostle Paul taught that the position that you hold is an established position that God has ordained, and you are his servants to pass judgment and to make decrees concerning law and order. But sirs and madams, as a servant of God also, and as a clergyman and as an ordained minister of the assemblies of God, I am asking for mercy from my friend who is also a part of my flock. I'm asking for mercy for 3 reasons. I'm asking for mercy from my friend Sean, because if there's been a man who needs mercy and clemency, I believe it is he. I'm also asking for mercy for Sean because of his wife, Brittany, who has stood by him faithfully, and he and her, and for their future, it depends upon your decision. And lastly, I ask for mercy because of Sean's son, Drake, both from this parole board and the family who has also suffered loss. Ultimately, I care about everybody who is involved with this, those who have lost and those who are navigating in light of the family with the vines. In a world where you and I both work with men and women alike who were not raised in stable homes, where a father and mother were not a part of the picture, Sean and Brittany, I feel confident and I know they will raise their son in church, be faithful to God in their home and in their hearts. In conclusion, I can assure you personally that I will do all that is within my power to assist, to help, to guide, and to pastor this family and their continued path of righteousness, to maintain their connection to local church, and to pastor them the best that I know how. I will do my absolute best to resource this wonderful family, Sean and his wife and his son, with counseling, with prayer, and with the Holy Scriptures to assist him in being the best father, husband, and man that he can be. All Sean needs is, in my opinion, a chance to prove to everyone, including all of you that are in the room, that God can turn a mess into a miracle. So therefore, I ask you to please consider clemency to be granted in regards to these matters.
Okay. Thank you also, Mr. Miller. Okay, now let's get to the other side and y'all can speak in whatever order y'all want to go to the please state your name and relation.
I'm Mark Todd, I'm Hunter's brother. Dave Hunter was killed, changed our family forever. It is impossible to fully describe the shock and devastation we went through when we learned Hunter was gone. One moment we were a complete family. The next we were living a nightmare we would never wake up. I watched my parents suffer a pain no parent should have to endure. Standing at the graveside as they buried their son, knowing that'd be the last time they see him again. The grief never ends. It follows them every day. Every birthday, holiday, family gathering, there's an empty spot where Hunter should be. We've already endured the reality that the sentence was reduced from the original charge. Now we're being asked even less accountability through an early release. While Sean seeks a second chance, Hunter never received one. One of the greatest tragedies of Hunter's murder is not what was taken from him, but what was taken from his children. Hunter's children received a life sentence without their dad, and my parents received a life sentence without their son. If Sean serves the sentence originally imposed, he still gets a chance to reunite with his family. Hunter was denied all opportunities with his son. For this reason, I ask the board to deny Sean Vine's request. Thank you. And
I have things written, but I'm just gonna go wing it. I'm Natalie Todd. I'm the wife of the lady from Todd. Married to him for 9.5 years, and we had 2 beautiful children together that now are young. Hunter was a great application society, and where Mr. Vines gets to continue on and make an application later, ours is Rob. Hunter was very involved in the community, who not only affected our family, but also affected a lot of little boys. He was a coach for both my boys. He mentored children that lacked healthy home lives, and he was just a good example. He had integrity. He was kind. He was generous. He got up every single day and he worked to provide for his family, and not just for us, but for the little boys who could not afford sports fees, uniforms, you name it. So he loved our son, Peyton Parker, more than anything. Since Hunter's death, our boys have reached milestones that every father dreams of witnessing. Hunter was robbed of attending donuts with Dad. Watching them publicly give their lives to the Lord through baptism, and they love the Lord. They love the Lord. Celebrating their signing days to play sports that they love, to the colleges. Both of them went on to graduate, play college football. They were students of the year, both of them. They achieved many recognitions throughout their years in high school and on into college. The moments that should have been shared between a father and his sons, instead, they were bittersweet reminders of the empty seat that Hunter should have been there. Every birthday, every graduation, every achievement, every has been marked by the painful absence of the man who should have been standing there beside them and beside me. I also ask you to consider Mr. Vine's history and the choices that he made before and after this crime. His criminal record reflects repeated disregard to the law, and his actions surrounding the case demonstrated a continued pattern of putting his own interests first. While he is asking for mercy today, our family has dealt with the permanent consequences of his decisions for more than a decade. Sean chose to rob my children from their father, Hunter's family from their son, their uncle, their cousin. He also chose to rob his own child from all of the listings and achievements I just listed. But he does get to go on and watch him become a young man. He gets to go to their wedding, his wedding. He gets to see his grandchildren one day. He gets to pick right back up in just a few short years. My sons and I believe in forgiveness. We do not harbor hatred. However, forgiveness does not erase accountability. When they would get in trouble, and they did, not bad trouble, but there was a punishment and it had to be served. That's how you learn. We believe actions have consequences, and the decision to take a good man's life should carry the consequences of serving the full sentence imposed by the court. We've also never received an apology or an acknowledgement of the pain that has been inflicted on Hunter's family, the parents, his brother, his friends, and most importantly, his children. As you consider the request for clemency, I ask that you remember not only the person seeking release, but also the man whose life was outshorted in the family. That continues to live with a lot. We continue to live with the loss every day until we all take our last breath. Please consider Hunter's legacy of service, because he has a long one in the short years that he lived on this earth. Please consider Hunter's legacy, compassion, hard work, faith, and fatherhood. I beg you. Thank you.
Morning, board. My name is Peyton Todd. I'm the oldest of five
2 sons. My dad was murdered when we were 6 and 10 years old. We were too young to fully understand the weight of Mr. Sean's decision on our lives. We were too young to speak in court. So it's a privilege to be here today to speak on behalf of my. The coolest thing about parenthood to me is that you get to make a choice. Whether you're going to be your kid's first superhero or their first villain. And that was never a choice for my dad. I used to think my dad could throw the football a mile and outrun a car until he pulled his hamstring racing me after practice. And to my little league teammates he was coaching on her, the first to arrive and the last one to leave. We'd wait around until after dark if a parent was late to pick someone up. Oftentimes we drove across town to drop them off, blasting Queens, we are the champions. And that was the superpower of his that I've matured to adore the most. That was his heart. The way he nurtured, protected, and made sure those around him felt loved is the superpower that I aspire to. He has always been my hero. Until recently, the last memory I had of my dad was him telling us that he loved us in the Cracker Barrel parking lot. The thought that he was likely pleading for his life when he was shot, pistol whipped on the back of the head, is a comic book ending that you try to keep from telling a 10-year-old to preserve the image of his dad. The soul of my family was ripped away. I watched my brother suffer from separation anxiety for years, and I became very good at suppressing my emotions. And I often criticize myself for finding it hard to empathize with those closest to me over everyday hardships, because nothing will ever compare. I've had plenty of experiences worth being anxious about, such as playing football in Tiger Stadium, just as my dad dreamed for me. I can confidently say that I've never had more sleepless nights as I've had preparing for the day. One thing that college athletics taught me is that actions have consequences. A lesson that we're not convinced that Mr. Vines will learn if he's released today. Not one coach in the country would continue to bail me out of punishment if I showed up late to 10+ practices. The last thing I'd like the board to consider is Mr. Vines was able to get his sentencing pushed in order to spend time with his newborn child. And whether he gets out today or a few years from now, he'll have the rest of his life to fix that relationship. My brother and I would give anything to spend that time with our dad, but that option was selfishly decided for us, and for that, we'll continue to be punished the rest of our lives. Thank you.
That would be proud.
Thank you, sir.
Okay, let's get into the you said you took some classes. What kind of classes did you take? Prepare yourself for release.
I completed AA general membership, the 12-step program, which is another step of that. Celebrate recovery, anger management, victims awareness, parenting, thinking for a change, living in balance. I completed a 9-month Bible study course. And
what was your favorite class? Tell me, what was your favorite class that you got the most out of?
Victims awareness.
Okay, and what did you learn from victim awareness?
Just about what everybody's been talking about, the pain that and the domino effect that it has not only on the person that I hurt, but their loved ones, my loved ones, the community. Every aspect of society actually was impacted because of my actions.
All right, and okay, go ahead if you have some more to say.
Well, I was just going to say that the direct impact victims, and I guess the non-direct ones as well. I guess I don't, for lack of better words. Just that was what I took. I took the most out of that class to heart. And I agree with what's been said by everyone there today who opposes me. And also, the reason that I've never apologized is because it was deemed, I was advised by a professional in Department of Corrections that it would not be appropriate to attempt to apologize at that time.
And I'd just like to state that you're not allowed to contact the victim's family.
Right. Yes, sir.
Okay. All right. Well, tell me this. This was an ongoing dispute. It seems like, correct?
Yes, sir.
And it finally came to a head. Is that what happened that night? I see y'all were dancing, and the next one thing led to another. So you told him to come to your house? I saw, was he texting wanting you to go somewhere else?
Yes, sir, I did. Yes, he was, and yes, I did.
Okay. Did you have your gun already ready, or did you have to go get it when he got there, or what?
Well, I at that time I rode with a firearm in my truck. It wasn't for any purpose of self-defense or anything like that. It's just something I did. I've always done.
Okay, and let me add this. Was the victim alone, Mr. Todd? Was he alone, or did he have someone with him?
He had two people with him.
Okay. Did they get involved at all in the fight?
No, sir.
And who was with you besides your wife? Just you, or you had some other people at your house?
I had it was me and my wife and two friends of mine.
Okay. Okay. And the sentence was a result of a plea bargain, correct?
Yes, sir.
How many years have you served?
11 years, 11 and a half, roughly.
Okay. All right. What is your job at prison? What do you do? Or what you do?
Right now I work at the West Cal at Rodeo Arena and Event Center. I'm on work release.
Okay. Yeah, you sending money home? You saving money?
Yes, sir.
Okay. I have no further questions. My colleagues have any questions?
Got one, and you're gonna clear it up for me. I have on here that you have a remaining time of approximately 7 years, but when you were talking, did you say that you had 2 years and 10 months left?
Diminution date. He gets out 4/29.
Right.
I should ask what he was actually.
Yeah, so I figured that was good time. So actually, your release date would be in 2 years and 10 months, correct? Because of good time?
Yes, ma'am.
Okay, I did want to ask that. And then, yes, the families, they don't tend to know this, but I know that going to court with victims, yeah, I would always tell them that the defendant, they're advised not to say they're sorry and stuff like that. And then further down the road, this kind of thing happens. And I don't know if you've written an accountability letter. That's something that the victim, if they want to check into, they can and read your words. And then, of course, we had the victim offender dialogue, which those are two good things for the victim and the offender, should they both want it. I did want to mention that. And because there was a lot of talk here today about forgiveness and trying to understand different things. But yeah, I understand too, there's a reason that you weren't able to reach out to them, because that's against the law. So you've done your best there, and you've done great with your programs and the victims. Their loss is so real, and that's ongoing. But your family also. So yeah, there's broken hearts all over this room today. Thank you very much, sir.
Mr. Vines, you mentioned you work at the rodeo arena place. What do you do?
General maintenance. I operate equipment. We take care of the dirt there. We do everything. They have an indoor event center. We set up you know, for different events, weddings, concerts and things of that nature. And we do a little bit of everything.
Okay. And what kind of, community service do you do within the prison environment? Do you do any?
Ma'am,
What kind of community service do you do within your prison environment?
every opportunity I have to give good advice, I take that opportunity and do so. And basically I try to be a voice of reason in anybody who's willing to hear. And, that's really it at the moment.
Okay, and let me just mention that generally when we have a clemency review for someone who's incarcerated, we will generally consider giving them parole eligibility. However, your good time date actually precedes your parole eligibility date. So
Yes,
what
ma'am.
is it that you're hoping to accomplish today?
Like the pastor said, he was asking for mercy. I'm not asking for you to believe that I deserve to get out early, because I don't. Honestly, the wages of sin is death. So I really only have life by grace through faith in Christ. And I'm not really asking you to do anything, but if you would give me mercy, then I would welcome it. That's basically really all I can ask for or hope for. And if not, then I will understand.
All right, well, I don't see any other questions. I do believe we're prepared to vote, Mr. Freeman.
Okay. All right, Mr. Bond, this is a very tough case. You've done very, very, very well in prison. You've done well with your family. I mean, I'm looking at that. You have tremendous support. But then on the other side, you took a plea bargain. You got 18 years for your sentence, which is not a big sentence. It's one of the smaller we see. You've only done 12 of that, so you've done 75%. So today, due to the victim opposition and the sentence was a plea bargain and the law enforcement opposition, my vote today is to deny.
Mr. Tillis,
I concur with Mr. Freeman.
Ms. Stapleton,
I concur with Mr. Freeman.
and Mr. Prater.
I concur with him, but I also want to say I'm very impressed with the interview. I'm very sorry for this, the way it all happened, but continue to keep your faith and do good, and I know you will.
Thank you.
Mr. Vines, I do, it's a difficult balancing today in your case because we have a lot of pain in this room on both sides. You said you suffered greatly, but I think everybody that we see here today has suffered greatly and continues to suffer. Based on the opposition in the record that's been expressed, the negotiated sentence that you agreed to and they agreed to, and the proximity of your good time mandatory release date. My vote today also is to deny. But I do agree with Mr. Prater's suggestion. Keep doing what you're doing. Keep your faith. I think you're doing well and you will be successful when you do get out. Good luck to you, sir.
So I just realized, because I made a couple of changes a couple of weeks ago to how we do this stream, that I don't have my allowed and denied stingers hooked up. Got to fix that. Tim gifts 5 more memberships. Thank you, Tim. I appreciate you very much. Very generous today. Thank you so much. Let's do this. Keeping with our channel's promise of 9 to 11% more Judge Boyd, let's go say good morning to her.
All right, everyone, please whisper. Court is calling 2026 CR 005743 and 2026 CR 006484, State versus Justin Pettis. Can I have parties announced?
Megan Galloway for the state.
Robert Maurer for defendant, Your Honor.
And are you Mr. Pettis?
Yes, sure.
Counsel, in each cause number, have you received all discovery and reviewed it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Pettis, in each cause number, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
In each cause number, did you review the true bill of indictment?
Yes, Your Honor.
Counsel, do you waive the reading?
We do, Judge.
State, in the DWI, you're proceeding on the indictment as presented?
Yes, sir.
And in the other cause number, are you proceeding on the indictment as presented?
That's our understanding, Judge.
All right, Mr. Perez, in each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Sure.
Right, in the cause number ending in 4-3, the state is proceeding on the second-degree felony, possession of a controlled substance, penalty group 1, 4 to 200 grams. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. And the cause number ending in 8-4, you're charged with driving while intoxicated, third or more. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? And have you understood all of the rights that I've talked to you about so far?
Yes, Your Honor.
All right, counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am, he is.
Mr. Perez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the cases are to run concurrently. Punishment is to be assessed at 6 years in the prison. There's a $2,000 fine. And any objections to the court correcting the plea bargain page and the number ending in 4-3 to reflect that you all are proceeding on count 2 only? Yes.
Yeah, that's all right. Yes, please.
Okay. Oh, no problem. All right, did you understand that to be your plea bargain agreement?
Yes, Your Honor.
State defense?
It is, Judge.
All right, in each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Any such motions?
No, Judge.
Outside the agreement, the state is asking that your probation be for a term of 5 years. There be TAP evaluation, 200 hours community service restitution, DWI intervention, victim impact panel, ignition interlock for half the term, and the DOEP course. And also 10 days as a condition in the Bexar County Jail. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, Your Honor.
All right. With regards to what's outside the plea bargain agreement, it's the 10 days in the Bexar County Jail. So usually what I do, because there's overcrowding at the jail, health issues at the jail, I usually give people a choice if the state has no objection. You can either do the 10 days day for day in the Bexar County Jail, which would start today, or if you want partial GPS, if it's for work only, then I will give you GPS for 20 days. The fees will be waived on GPS. You'll only be allowed to go to and from work. That's it.
GPS, please.
State, do you have any objections with that? No. All right. Then in each cause number, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
No objections, Judge. And Judge, on the plea bargain, the only issue I wanted to raise is he doesn't have a vehicle. He currently has the portable device. And so I was going to ask the court to continue with that unless at some point in the future he gets a vehicle.
Okay. And state, will you be having any objection to that?
No, Judge.
All right, thank you. All right, thank you. All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Sure, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation, testimony, and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, in each cause number, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find your client guilty, and the court will find your client guilty. Are you proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
Judge, we just asked the court follow the plea bargain.
All right. All right, probation, we're going to start with 2026 CR 005743. All right, Mr. Pettis, are you employed?
Yes, ma'am.
What do you do?
Temp agency.
And do they just send you to different places and it's different type of employment?
Yes.
All right, so in this court, I don't allow people on certain type of probations to be home healthcare providers. So if they're sending you out to do that, it's not allowed. Do you understand? All right, do you have any children?
Oh, ma'am.
And do you live by yourself or with someone?
Family.
And what family member? What's their relationship to you?
Mother, father, siblings.
All right, and are the siblings underage or no?
No.
So they're not minors?
No, they're not minors.
Okay.
I'm sorry, one minor and one is of age.
All right, and the minor, how old is the minor?
13.
Right. All right, this is what the court is going to do. The court is going to sentence you to, of course, find you guilty as previously stated. And that cause number, the court is going to sentence you to 6 years in the prison. Suspended and probated for 5 years. There's to be regular reporting by Zoom or in person. Regular UAs. $2,000 fine, that will be probated. This is run concurrent with 2026 CR 006484. 200 hours of community service restitution. They're asking for the DOEP course. So once you've completed that course, 100 hours will be deducted. The remaining hours will be deducted at 1 hour deduction for every sober support meeting that you complete. So, you know, it's hot in Texas. So you can either work picking up trash, which is what they'll have you doing, or either you can do sober support meetings. I'm going to do 20 days GPS partial, waive fees, and it's for employment only. And that's really not under that cause number, Ms. Abrams, it's under the DWI cause number. Field visits 1 time per month for 3 months. Proof of employment within 30 days. No employment as a home health care provider or with minors. TAP evaluation, out of custody. Probation, is there anything else with regards to that cause number? Under that cause number, is there anything that you need from the court in order to be successful?
Oh, Your Honor.
All right. And that cause number, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right. I'm sorry, that goes here. All right, next we're going to proceed in 2026 CR 006484. As previously stated in that cause number, the court found you guilty. Court is going to sentence you to 20 days GPS. Partial for employment. And that's in lieu of 10 days in the Bexar County Jail. And for the record, the court is entering the 20 days partial GPS due to the overcrowding at the jail and health issues. And counsel, would it be a financial detriment to your client if he were given the 10 days in the Bexar County Jail?
It would, Judge.
All right. There's to be regular reporting by Zoom or in person, regular UAs, $2,000 fine that will be probated. This will run concurrent with 2026 CR 005743. Court will sentence you to 6 years in the prison, suspended and probated for 4 years, 200 hours community service restitution. Court will deduct 1 hour for every sober support meeting that is completed. The court is going to order. Sorry. Yes. You want me to start over? Okay. All right. So 200 hours community service restitution. 1 hour will be deducted for every sober support meeting that is completed. The court is going to deduct 50 hours for completion of the DWI intervention course. And there will be a 50-hour deduction for completion of the victim impact panel. I'm going to want the live one. There can be a portable alcohol monitoring device for half the term upon affidavit of non-driving. And proof of non-ownership of a vehicle. So basically what will end up happening is they will see that you don't have vehicles, right? So here's the thing. The vehicle that you were driving in this case, was that your vehicle?
No, ma'am.
All right. So here's the problem. Whose vehicle was that?
The rental.
All right. So then here's the thing. You are not allowed to drive any vehicle. If you drive a vehicle and that vehicle does not have the ignition interlock on it, you have violated your probation and you're looking at 6 years in the prison if it's proven to be true. Do you understand?
Yes, Your Honor.
And what I can tell you is proving up allegations and motions to revoke, your attorney will tell you that's very easy because the standard is not proof beyond a reasonable doubt. More likely than not. Is it true? And if it is more likely than not against you, then it's going to be found true. And you're looking at potentially 6 years in the prison. You understand?
Yes, Your Honor.
All right. Proof of employment within 30 days. No employment as a home health care provider or with minors. 2-year license suspension. Probation. Is there anything else that I'm missing?
On that case, and then it's been no driving an actual condition that you want.
Well, he's not allowed any driving with a vehicle that doesn't have ignition interlock. And for him to be allowed to continue on the PAM device, he needs to provide an affidavit of non-driving. All right, so field visits 1 time per month for 3 months. Probation, anything else?
Okay.
Is there anything else you need from the court in order to be successful?
No, Your Honor.
Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Oh, I'm so sorry. TAP evaluation out of custody.
Yes, ma'am.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what that is, you'll need to speak to the attorney. Do you understand?
Yes, Your Honor.
So let me explain something to you. And I think your attorney will agree with me on this. I have yet to meet anyone who gets drunk, goes out, has an accident and kills somebody. I've yet to meet someone as a defense attorney or prosecutor or as a judge who said, you know what, my intention was to drink to intoxication, drive, hit and kill somebody. Have you ever ran across somebody?
No.
You know what ends up happening? You end up getting intoxicated, you losing your mental faculties, right? And you think you can drive, you think everything is okay. And usually when you hit somebody, the person who's intoxicated, it's rare that they're injured, right? It's usually somebody else. And then you're before the court crying, asking for mercy because can't believe you killed somebody. You're probably one of those people who cannot drink alcohol because you don't know when to stop. Your body chemistry is telling you, let's continue to drink. You understand?
Yes, Your Honor.
So just think about it. You could have been driving, could have hit one of your siblings, right? Somebody else could be driving, hit one of your siblings. Don't be a part of the problem. And while you're on probation, you are not allowed to drink alcohol. That's one of the rules of probation. You understand?
Yes, Your Honor.
All right, good luck to you. If you need something, be sure to let probation know. If you feel as though you need more help with maintaining your sobriety than what I've given you, let us know. Let probation know. They're here to help you, okay?
Yes, Your Honor.
All right, good luck to you.
Thank you,
for
Judge.
dressing appropriately for court. You're welcome. Who's next?
Sadly, Judge Boyd has had to stop saying the words, come back and see me and I'll find you help, because she's not going to be there in a few months. Alrighty, friends, TCF Live on a Monday. We've got about 10-15 minutes left to go. Let's stay in Texas, but we'll rotate back over to Judge Stevens. The lady in red is approaching.
I'm talking with Miss Moore on one of hers, trying to figure out if that one's going to be dismissed or not, and then what the direction of the others will be.
Okay,
If we could have 2 weeks on that.
you got 2
I think
weeks. All right. And ma'am, your name, please.
Crystal Bass.
Your Crystal Bass. Okay, you've got 2 cases, Miss Bass. In 25 CR 1809 and 1810. Assault on hospital personnel and hospital property. Each of these cases on or about, well, one was alleging on or about November 8th, 2025, that event. And the other is on or about October 14th, 2025. And then the indictment, God bless you, goes on to allege that in 2019, you were convicted out of Hardin County District Court for attempted aggravated assault. So these 2 charges on assault on hospital personnel are 3rd-degree felonies. If all of this was found true in these indictments, your punishment range is a 2nd-degree felony. You're looking at no less than 2, no more than 20 years confinement in prison. Probation is not an option because you have, according to the indictment, been previously convicted of a felony, which eliminates any probation. Let me look at this. And she had earlier been evaluated by Dr. Ed Grapon before the issue of competency to stand trial and Dr. Lipon in a letter dated June 26th of this year, so, a week or so ago, deemed the defendant to be competent to stand trial. In this evaluation, which the court is going to mark as court's exhibit 1. This day. In each of these cases.
Every single one of them is an evaluation.
I don't have enough room behind. Gotta use 2 exhibit stickers. Yes, this is court's exhibit 1 in for each of these cases. Part of the record and seal the set purposes of related issues that may come up during the trial. What are we doing?
Judge, I just wanted to go over her options with her. She has a current offer from Tommy Coleman, the new prosecutor in her case. That's only good for today. He's offering a plea for 2 years, running concurrently on each case. After today, that offer will go up to 5 years. As you explained to her, you do have 2 pending third-degree felonies. You understand that, right?
You have to speak out so she.
And then with that prior that you have on your record, you understand that you wouldn't be eligible for any kind of probation out of trial. Okay, and with that prior that you have on your record as well, that would also enhance you to a higher punishment range. So instead of your punishment range at trial being the 3rd-degree felony range of 2 to 10, it would enhance to 2 to 20. You understand that? You understand that you have a current offer on the table for 2 years TDC, and then you have 140 days credit.
Yes, ma'am.
Okay, and are you wanting to accept that offer, or do you want to set your case for trial?
I'll accept the offer.
Okay.
Okay, is this a plea in each case?
Yes.
To run concurrently, right? That's your understanding.
Is that what you want to do? You can set your case for trial.
Write it up.
I just need to make sure that you understand all of your options.
Write it up. That's good today.
Okay.
Thank you. All right, thank you. We get to this here. Did you say a Burkett as a bond hearing?
All right, friends, a couple more minutes to go. Let's finish off the day with 1 or 2 more from Judge West.
And good morning. Are you Akaya Nash?
Yes, ma'am.
And this is 26 DCCR 0206. Ms. Nash is charged with aggravated assault with a deadly weapon. And what is the announcement?
Judge, I spoke with Ms. Nash and who's to stay in this situation. We've gotten an offer on it. There's an alternative offer there as well. So I just need a little time to talk to Ms. Nash to see what's going to be which option she wants to proceed with.
All right, we'll just do one more reset. Ms. Nash, it's important that you make an appointment, go visit with Mr. Lewis before that next court date. So y'all can go over all of your options and we'll get an announcement of what you want to do at the next court date, okay?
Yes, ma'am.
All right. Charles Toussaint.
Charles Toussaint. Hey. I have that two convictions.
Oh, that's the one that had a hard time getting turned in and all that or something.
He's breaking the rule.
I think I want those two big chairs taken out of here. We never have that many people in here, you know, and they're just in the way and they don't match and they stick up.
What?
You're there.
Good morning, sir. You are Charles Toussaint.
Yes, ma'am.
This is cause number 26 DCCR 0527. Mr. Toussaint's charged with unlawful possession of a firearm by felon. And what is the announcement?
Judge, Mr. Toussaint has provided me some medical records that I need to, one, fully review myself because it would definitely have a definite impact on whatever's offered or whatever would be in this case. Well, I've let Mr. Smith know that, so if I can just get a little time to review that myself and just talk with him.
All right. Any issues, Mr. Smith? All right, sir, I'm going to reset your case about 30 days or so. Make sure you call Mr. Lewis, get in touch with him. Y'all visit before that next court date so we can get an announcement at the next court date.
Okay.
All right, you're free to go, sir. You can go back out that same way. Yeah.
Yeah, I'm talking to you outside. I'll be a friend soon.
Alrighty, friends, I think that's going to do it for today. I hope you all had fun. I know I did. Thank you to everybody for your generosity and your friendliness and everything else today that you always bring to the table. It is very much appreciated. The wisdom I leave you with today from Ecclesiastes, be not quick to anger, for anger lodges in the bosom of fools. So give that some thought. Tonight, sidebar. 7 p.m. Eastern, 4 p.m. Pacific. Do join us for that show. It is not courtroom related. It's a different thing that Michael Groff and I do. It is all sorts of fun. If you haven't checked it out before, please do check it out tonight. As soon as I end the stream, it will redirect you over there so that you can set a reminder to join us. Again, thank you so much. Hope you all had fun. We'll see you again tomorrow morning here, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour early if you are a channel member. Did I say the sidebar? Oh, heck. In the Blind with Mike and Dan tonight, 7 p.m. Eastern, 4 p.m. Pacific. Whatever. There's so many shows. I'm like always behind the camera, guys. I mix it up. We're going to be in the bar tonight. We're going to be blindsided. I don't know what it's called. Just hang tight until the stream is over and it'll send you over there and then you can figure out what it is. All right. This has been fun. We'll see you tonight and tomorrow and all of that. Take care. God bless.